The Royal Commission into Violence, Abuse, Neglect and Exploitation is now in session.
Good morning, everybody. I welcome everyone who is participating in or who is following these proceedings, that is Public Hearing 18 of the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability. I wish first, on behalf of the Commissioners, to acknowledge the Gadigal people of the Eora Nation, on whose traditional lands the Royal Commission is sitting today, and to pay our respects to their elders, past, present and emerging. We also pay our respects to all First Nations people who are following this hearing. The Royal Commission is not yet able to hold a public hearing which members of the public can attend in person. However, we have made a little progress in that today the Commissioners participating in this hearing are all in the Sydney hearing room. I'm joined by Commissioner Alastair McEwen AM and Commissioner John Ryan AM. Senior Counsel assisting the Royal Commission, Ms. Kate Eastman SC, is also in the Sydney hearing room. The subject of Public Hearing 18, this public hearing of the Royal Commission, is the human rights of people with disability and making the Convention on the Rights of People with Disability a reality in Australian law, policies and practice. As I noted in my opening for the Royal Commission's very first public hearing, the ceremonial hearing that was held in Brisbane on the 16th of September 2019, our terms of reference have a human rights focus. The preamble to the terms of reference, that is the introductory paragraphs, expressly refer to the human rights of people with disability. The preamble recognises that people with disability are equal citizens and have the right to the full and equal enjoyment of all human rights and fundamental freedoms, including respect for their inherent dignity and individual autonomy, and that Australia has international obligations to take appropriate legislative, administrative and other measures to promote the human rights of people with disability, including to protect people with disability from all forms of exploitation, violence, abuse and neglect under the Convention on the Rights of Persons with Disabilities. In our interim report, which was published in October 2020, we stated that our inquiry is framed by human rights and that we intended to apply an approach informed by human rights. We made several important points relevant to determining what it means to adopt a human rights approach to our work. I think it is useful to refer to these points and to make some additional observations. I apologise in advance if this sounds like an introductory lecture on international and constitutional law, but that is the territory we are entering, at least in part. Of course, what I'm about to say is necessarily incomplete, but it is designed to explain some of the background to the subject matter of this hearing. First, unlike the United States, Australia does not have a constitutionally entrenched Bill of Rights. One important reason why the framers of the Australian Constitution rejected the American model was the fear that a Bill of Rights would prevent full implementation of the White Australia policy, which in fact persisted in this country until the 1960s. Given the recent American experience with a partisan Supreme Court interpreting constitutional guarantees, our founders might have been wiser than they knew. In any event, what we have been left with is a few miscellaneous express constitutional safeguards, but no protection in our Constitution, at least in the express words of the Constitution, of what we would understand now to be human rights. Perhaps the provision that comes closest is to a guarantee of human rights is Section 116, which prevents the Commonwealth, but not the states, from prohibiting the free exercise of religion. In practice, Section 116 has proved virtually meaningless. Second, not only does Australia lack a constitutionally entrenched Bill of Rights, we also do not have a federal or national legislative Charter of Rights. Broadly speaking, the difference is that under a constitutionally entrenched Bill of Rights, courts usually have the power to declare legislation invalid if it infringes a guaranteed freedom, such as freedom of speech. In other words, if rights are given constitutional status, the courts can override legislation passed by a democratically elected parliament, and basically there is nothing that parliament can do about it, short of a constitutional amendment. With a legislative Charter of Rights, courts generally have power to declare that a law is incompatible with a particular human right set out in the Charter, but the court does not have power to declare the law invalid. It is therefore Parliament that has the final say whether a law remains on the books, even if it breaches human rights. In other words, under that system, Parliament, as the elected body of lawmakers, is supreme, but in theory at least, is accountable to the electorate if it is found to have ignored or contravened human rights. Although the Commonwealth Parliament, the Australian Parliament, has never enacted a statutory Charter of Rights, 3 Australian jurisdictions have done so: the Australian Capital Territory, Victoria, and more recently Queensland. They have adopted the so-called dialogue model of human rights. Of course, each of these charters operates only within the particular jurisdiction, not nationally, and each is necessarily subject to valid Commonwealth laws. And that is because under the Australian Constitution, Commonwealth laws take precedence over any inconsistent state or territory laws. We shall hear tomorrow from the ACT, representatives of the ACT Human Rights Commission. They will no doubt explain that most of the human rights enumerated in the Human Rights Act 2004 of the ACT are based on the provisions of the International Covenant on Civil and Political Rights, while 2 of the enumerated human rights are derived from the International Covenant on Economic, Social and Cultural Rights. The ACT Charter, as I call it, makes no specific reference to the rights of people with disability, although the notes incorporated in the legislation state that prohibited discrimination includes discrimination on the ground of disability. The position so far as the rights of people with disability are concerned is broadly similar under the Victorian and Queensland charters. Third, when Australia enters into an international treaty such as the CRPD, the Convention on the Rights of Persons with Disabilities, it undertakes obligations under international law. However, an international treaty entered into by Australia does not form part of Australian domestic law unless and until it is implemented by legislation. Therefore, no one can make a claim in an Australian court for relief based on an alleged contravention by the Australian government, or for that matter, the government of a state or territory, of a human rights convention to which Australia is a party, unless a parliament has enacted a law to give effect to the terms of the convention in Australian domestic law. As many people following this hearing will know, under the optional protocol to the CRPD, to which Australia is a party, the United Nations Committee on the Rights of Persons with Disabilities is competent to receive and consider complaints on behalf of individuals who claim that Australia has violated provisions of the CRPD. In fact, the UN committee has upheld a number of complaints by Australian citizens, but Australia is not bound to accept or implement decisions made by that UN committee. There are usually said to be 7 core international treaties to which Australia is a party. They are the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the International Covenant on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against women, the Convention Against Torture, the Convention on the Rights of the Child, and of course, the CRPD. The Commonwealth Parliament under our constitutional system clearly has power to enact legislation to give effect in domestic law on a national basis to Australia's obligations under any international treaty, including human rights conventions. That is because the Constitution empowers Parliament to make laws with respect to, quote, external affairs, unquote. And the High Court has interpreted that to include the power to implement by legislation Australia's obligations under international law. However, the Commonwealth Parliament has not fully implemented any of the core human rights treaties into Australian domestic law, although it has given effect to particular provisions. For example, the Racial Discrimination Act 1975 gives effect to some of the provisions on the Convention for the Elimination of All Forms of Racial Discrimination. Relatively little of the CRPD has been expressly implemented by legislation in Australia, whether by the Commonwealth, the states, or the territories. The Disability Discrimination Act 1992 is consistent with the CRPD, but its enactment actually predated Australia's ratification of the CRPD by about 17 years. In 2009, the Disability Discrimination Act was amended to give effect to particular provisions of the CRPD, including by defining the term discrimination to incorporate a denial of reasonable accommodation to a person with disability. That was a very important amendment and followed the terms of the CRPD. One of the stated objectives of the National Disability Insurance Act 2013 is to give effect to Australia's obligations under the CRPD. So it is certainly true that the CRPD has been implemented in Australia to some extent, but not to a great extent. Fourth, all multilateral international agreements like the CRPD and other human rights treaties are the product of lengthy negotiations and compromises among numerous parties, including the representatives of the very many nation states participating in the drafting process. In a different context, the events in Glasgow over the last week or two are an illustration of that. Compromises are also characteristic of much domestic legislation, particularly when a government does not command a majority in both houses of Parliament, remembering that Queensland has only one house. But the compromises required to secure agreement to the text of a treaty intended to bind 150 or more nation states are of a much greater order, particularly when we recall that drafts must be negotiated and then translated into multiple languages. The consequence of the negotiations and compromises required to secure agreement to the text of a human rights convention is often that the text uses very general or ambiguous language that lends itself to different interpretations depending upon the perspective of the observer. The differences in interpretation or understanding may persist for a very long time because international law has no mechanism that provides for an authoritative and binding interpretation of human rights conventions, including the CRPD. Nor does international law provide for effective enforcement mechanisms for violations of the CRPD by states parties. The Australian government has submitted a background paper to the Royal Commission on the CRPD. The background paper, which I think will be referred to during this hearing, appears to suggest that Australia is fully compliant with its obligations under the CRPD. By contrast, many scholars and advocates disagree with the Australian government, assuming that it does in fact say that Australia is fully compliant with the CRPD. For example, Emeritus Professor Ron McCallum prepared a research report for the Royal Commission in which he identifies numerous articles of the CRPD that, in his view, Australia has not implemented in full or perhaps at all. Professor McCallum's report, entitled The CRPD, An Assessment of Australia's Level of Compliance, has been published by the Royal Commission and is readily available to anybody who wishes to read it. Fifth, even when human rights conventions have not been incorporated by legislation into domestic law, principles of international law can be used by courts to develop the common law and to interpret domestic legislation in a manner consistent with Australia's international obligations. An example is the foundational Mabo, the native title decision in 1992. In that case, Justice Brennan, later the Chief Justice of the High Court of Australia, recognised that international law is a legitimate and important influence on shaping the common law in modern circumstances, particularly where international law declares the existence of universal human rights. A comprehensive study published in 2018 ascertained that Australian courts and tribunals have relied on the CRPD from time to time to support the interpretation of a law that is favourable to a person with disability. One case in the Supreme Court of Victoria, for example, relied on Article 12 of the CRPD, which recognises that people with disability enjoy legal capacity on an equal basis with all others in all aspects of life. The court relied on Article 12 to support an interpretation of the state's guardianship legislation to enable a person who had an acquired brain injury and whose funds had been managed on his behalf to regain control of his own funds. However, that study in 2019 also found that references to the CRPD by that time, in the reported case law at least, were very few and far between. This may well reflect a lack of awareness among the legal community of the human rights recognised by the CRPD. Sixth, as the CRPD recognises, human rights are universal, interconnected, and indivisible. People with disability have human rights founded on the principles articulated in Article 3 of the CRPD, including respect for inherent dignity, individual autonomy, the freedom to make one's own choices, independence, and full and effective participation in society. But it is necessary, however, to recognise that sometimes human rights can actually conflict with each other, and the process of reconciling them can prove to be challenging. Let me give you an illustration from a case decided by the Supreme Court of Canada just over a week ago. The case concerned a professional comedian who mocked the physical characteristics of a well-known young singer. The singer was a secondary school student and had significant physical disabilities. The comedian also made disparaging comments of a different kind about other well-known non-disabled performers. But the disparaging comments he made about the young singer specifically concerned the disabilities of that singer. The Supreme Court of Canada saw this as a clash between two fundamental freedoms guaranteed by the Quebec Charter of Rights: the comedian's right to freedom of speech and the young singer's right to full and equal safeguard of his dignity. A majority of the Supreme Court of Canada upheld a finding that the comedian had selected the singer to disparage him, not because he had a disability, but because he was a public figure. In these circumstances, so the majority decided, the comedian's freedom of expression prevailed over the singer's right to the safeguarding of his dignity. The point here is not whether the Supreme Court of Canada got it right. As it happens, I do not think it did, but there again, I'm not a member of the Supreme Court of Canada. The point is that human rights are not necessarily always absolute, because they can conflict with other human rights. In addition, human rights sometimes may be subject to limits, whether imposed by the language of a convention or the terms of domestic legislation. The ACT Charter, in common with the Victorian Charter, for example, permits reasonable limits to be imposed on the enumerated human rights in the ACT legislation, provided the limits can be demonstrably justified in a free and democratic society. That is a formulation that is often used in domestic legislation in other countries. Seventh, it's necessary to remember that not all human rights are created equal. So-called civil and political human rights are regarded as rights of immediate effect. That is, a state party to an international convention recognising civil and political rights must adopt such laws and measures as may be necessary to give effect to those rights. Some important rights recognised in the CRPD are plainly rights of immediate effect, and therefore Australia is bound to implement them. Others fall into the category of economic, social or cultural rights that are, quote, progressively realisable, unquote. Article 4, subparagraph 2 of the CRPD states the principle, and I quote, with regard to economic, social and cultural rights, each state party, that means Australia in the present context, undertakes to take measures to the maximum of its available resources and where needed within the framework of international cooperation, with a view to achieving progressively the full realisation of these rights without prejudice to those obligations contained in the present convention that are immediately applicable according to international law, end quote. I make two final points. In each of the public hearings that we have held to date, we have identified the provisions of the CRPD that provide guidance on the issues examined at the particular hearing from the perspective of the human rights of people with disability. The published Commissioner's reports on the public hearings incorporate references to the relevant articles of the CRPD. For example, the Commissioner's reports on public hearings 5 and 12 examined the experiences of people with disability during the COVID-19 pandemic, including the Australian government's approaches to the rollout of vaccines to people with disability. Each of those reports has been tabled in Parliament and contains findings and recommendations. Each of those reports sets out the human rights framework created by the CRPD, within which the responses of the Australian government to the pandemic had to be assessed. They included Article 4, subparagraph 5, relating to consultations with people with disability, Article 11, requiring state parties to take all necessary measures to ensure the protection of people with disability in situations of risk, and Article 25, the right to enjoyment of the highest standards of health. Each of those articles and others informed our assessment of the response of the Australian government and contributed to the findings and recommendations made in the report. I should say that all but 2 of the recommendations that were made in those reports have been supported one way or another by the Australian government. Ms. Eastman, in her opening remarks, will provide more detail about the role the CRPD has played in other hearings and what we have learned from submissions and research about how human rights ought to be used to bring about a more inclusive society and protect people with disability from violence, abuse, neglect, and exploitation. The final observation is this. The observations I've made, none of which is particularly controversial, suggest that making the human rights of people with disability a reality in Australian law, policies and practices requires a great deal of thought. There are many factors to consider, not only principles of international and domestic law, but the practical world of resources, institutions, regulatory and monitoring systems, community attitudes, competing rights and interests, and as always, political processes. Ms. Eastman will shortly explain by reference to the evidence to be given over the next 2 days what might be involved in a human rights approach to promoting a more inclusive society for people with disability. Yes, Ms. Eastman.
Chair, if we're taking the appearances.
Well, we can take the appearances now, certainly.
I appear as counsel assisting the Royal Commission. I'm instructed by the Office of the Solicitor Assisting, and in the course of the preparation for this hearing, I've been assisted by counsel David Hume and Kate Beattie.
Thank you, Ms Eastman. I'll take the appearances of other parties given leave to appear. Can we start, please, with the Commonwealth of Australia? I hope the Commonwealth hasn't gone missing. Are you there?
Commissioners, I hope you can see and hear me now. Can you?
We can, well, at least I can hear you, but I cannot. Oh, I think I can now see you. Yes.
Yes. Commissioners, I'm sorry for that little technical glitch. I appear with my learned friend, Ms Palmer, for the Commonwealth.
Thank you, Mr Kennett. Queen, can we then have, please, the appearance for the State of Queensland?
Yes. Good morning, Chair and Commissioners. My name is McMillan, initials KA. I appear with my learned junior, Miss Chloe Hesse, instructed by Crown Law.
Thank you, Ms McMillan. The State of New South Wales?
If it pleases the Commission, my name's Gail Furness and I appear for the State of New South Wales, instructed by the Crown Solicitor's Office.
Thank you, Ms Furness. The State of Victoria?
Commissioners, my name is Scott Chesterman. I appear on behalf of the State of Victoria.
Yes, thank you, Mr Chesterman. And I think the State of South Australia has been given leave to appear, but I don't know whether there's an appearance today. Is there an appearance for the State of South Australia? No, all right, well, if not, if there is to be an appearance at a later stage, that can be announced at the appropriate time. Yes, Ms Eastman.
Thank you, Commissioners. I also acknowledge and pay my respects to the traditional custodians on the lands on which we meet today. I pay my respects to First Nations elders, past, present and emerging, as well as acknowledging all First Nations people following this public hearing. So this public hearing will focus on the human rights of people with disability and the implementation on the Convention of the Rights of Persons with Disabilities. The CRPD, as I'll call it, is an international law called a treaty or a convention. The CRPD is the result of negotiation between countries, including Australia. The CRPD sets out a range of human rights for people with disability, and it also imposes legal obligations on Australia to ensure and promote the full realisation of human rights. The CRPD has a number of general principles, and they include the following: respect for inherent dignity, individual autonomy, including freedom to make one's own choices and independence of persons, non-discrimination, full participation and inclusion in society, equal opportunity and accessibility. These principles guide the interpretation and the implementation of the specific CRPD rights. The CRPD rights are minimum standards, not a final destination. In Australia, international treaties like the CRPD are not automatically part of Australian law. The rights in the CRPD cannot be enforced by Australian courts or tribunals. And one issue in this hearing will be to address how international human rights laws become law and enforceable in Australia. So, Commissioners, when we talk about the CRPD, we are using a lot of abbreviations and a lot of legal terms. I'll do my best to try to speak in plain English, but some of these legal expressions come from the United Nations. So we have prepared a document which we hope will assist in working with the abbreviations and the various words. The document, which we've called Abbreviations and Words, is on the Royal Commission's website, and I encourage everyone to access that document so you can follow along with some of the evidence over the course of the next 2 days. So why has the Royal Commission decided to focus on the CRPD at this point in time? As the Chairs noted earlier, the Royal Commission's terms of reference identify the importance of human rights and the CRPD, and it's critically relevant to the way in which this Royal Commission undertakes its work. In addition to those parts of the terms of reference the Chair referred to, I also note that there is a requirement that the Royal Commission consider the following: innovative models of preventing, reporting, investigating, or responding to violence against and abuse, neglect, or exploitation of people with disability. Looking at innovative models includes looking at the way in which the CRPD could be implemented. Chair's touched on the importance of a human rights approach, and I want to say something about a human rights approach. A human rights approach assumes the existence of human rights, but it goes beyond merely enshrining those rights in law. Indeed, a human rights approach is proactive. It doesn't wait to respond after a person's rights have been violated. A human rights-based approach uses the human rights principles to guide and evaluate the development and implementation of laws, policies, and practices. A human rights-based approach requires an understanding of laws, systems, and policies that affect the lives of people with disability. Applying a human rights-based approach for people with disability poses the following questions. First, does a policy or program have the main objective to fulfil human rights? Have all policies and programs in all sectors and in all phases of policy making and programs been guided by the principles and standards derived from international human rights treaties such as the CRPD? A further question is to ask, have the rights holders and have their entitlements been identified, the right holders being the beneficiary of the rights set out in the CRPD? Identifying rights holders is one step, but a further step is to ask, have the corresponding duty bearers identified their obligations? And so one asks, do the policies and programs work towards strengthening the capacities of right holders to make their claims and of the duty bearers to meet their obligations? This means, for example, services should be designed and delivered in a manner that respects the recipient's rights. Services that do not pay attention to rights may unintentionally result in future rights violations. Ideally, that should be avoided. A human rights-based approach is person-centred. People with disability are the rights bearers rather than passive recipients. They should be included in the design and the decision-making. People with disability are active claimants of rights in relation to the duty bearers. Those duty bearers may be governments, private sector organisations, or anyone providing services and supports. It has been said that the real potential of human rights lies in its ability to change the way people perceive themselves vis-à-vis the government and other actors. A rights-based framework provides a mechanism for reanalysing and renaming problems as rights violations, and as such, something that should not be tolerated and should be addressed. Implementing a rights-based approach ensures that there is a focus on respecting the rights of people with disability, but most importantly, accountability on the duty bearers. Commissioners, we will consider what accountability means in the context of implementing the CRPD. And I note there are a range of mechanisms. You'll be aware, for example, of the 2019 UN Disability Inclusion Strategy, which applies to the work of the United Nations, and to some more recent indicators on the CRPD implementation released by the Office of the High Commissioner on Human Rights in November last year. So can I now turn to the influence of the CRPD on the Royal Commission's work to date? The influence of the CRPD can be seen in the 13 research papers published on the Royal Commission's website. These research papers address the human rights of people with disability, and there's two specific research papers that I'll focus on in the course of this hearing. The first is our first project and our first research paper published. It was prepared by Rosemary Cayas and Therese Sands in 2020, and it's entitled Convention on the Rights of Persons with Disabilities, Shining a Light on Social Transformation. This report was commissioned to describe the international human rights context in which the Royal Commission operates. You will shortly hear from Ms. Cayas and Ms. Sands. Ms. Cayas is currently the chair of the Committee on the Rights of Persons with Disability. The committee monitors the CRPD, and Ms. Cayas and Ms. Sands will tell you about their research, their findings, and the issues Australia needs to address to better implement the CRPD rights in Australia. The second project, but our second report was prepared by Emeritus Professor Ron McCallum in 2020. His report is the United Nations Convention on the Rights of Persons with Disabilities, an assessment of Australia's level of compliance. Professor McCallum was the first chair of the Committee on the Rights of Persons with Disabilities. His report is a detailed analysis of how Australia has complied with its international obligations. And Commissioners, as you are aware, Australia is required to prepare reports for the CRPD committee, explaining how Australia is ensuring and promoting CRPD rights in Australia. When the committee receives the Australian report, it reviews the report, it asks questions of the Australian government officials, and it publishes its own report called Concluding Observations. It is in effect a report card on whether Australia is meeting its obligations. You will hear about Australia's performance and the role of the disability advocacy groups in this process, sometimes called constructive dialogue. The CRPD has also influenced the work of public hearings. The CRPD has been raised in a number of public hearings to date, and Commissioners, may I remind you of some of the ways the CRPD has arisen in the public hearings. At Public Hearing 3, concerning the experiences of people with disability in group homes, that was held in Melbourne in December 2019, you heard Naomi Anderson, a solicitor from Villamanta Legal Centre, and she said, "Rights don't really count for much if they're not legally enforceable. If there's nothing you can do to enforce that right, it actually may as well not exist." At the same hearing, Dr. Colleen Pearce, the Victorian Public Advocate, was asked about translating human rights from abstract concepts to the practical implementation of those rights. She was asked, can these rights actually make a difference? And she said this, "I think it makes a difference in the way we approach our work and how we make decisions, how we involve people with disability in work of the office." They're referring to the Office of the Victorian Public Advocate. And she said this, "I think it's in those very small, intangible ways that we see differences in the office and the work that we do." At Public Hearing 4, concerning the healthcare and services for people with cognitive disability, held in Homebush, New South Wales in February 2020, Professor Julian Troller made note of Article 25 of the CRPD, the right of Australians with disabilities to the enjoyment of the highest attainable standard of health without discrimination on the basis of disability. He said this, "In my opinion, realising this goal for people with intellectual disability and for autistic people requires clinicians, health systems and policies that understand and respond adaptively to the complex and multifaceted impact of these developmental differences." At Public Hearing 5, concerning the impact on people with disability during the COVID-19 pandemic, held in August last year, you heard from the then Special Rapporteur for People with Disability, Ms. Catalina Devandis. She talked about the importance of the CRPD rights being central to the responses of governments during the time of the pandemic. At Public Hearing 9, concerning the systemic barriers for people with disability seeking open employment, Mr. Ed Siansky told you that after 25 years of his son trying to get a job, it had convinced him that there was, as he described, a cul-de-sac of neglect. And he said this, "It is shameful. I didn't realise that Australia had actually signed up to a convention on the rights of people with disability. And at paragraph 27 of that document says that everyone's got a right to a job of some kind." At the same public hearing, you heard from Dr. Ben Gauntlet, Australia's Disability Discrimination Commissioner, and he said the CRPD was the primary document which he needed to refer to when discharging his functions as the Disability Discrimination Commissioner. This is not an exhaustive list. The CRPD has also been raised in submissions, private sessions and responses to issues papers. In April 2020, the Royal Commission released its issues papers on rights and attitudes. The Royal Commission wanted to understand the laws, policies, practices and supports that are needed to reduce the risk of violence, abuse, neglect and exploitation, and referred to the lack of rights awareness among people, organisation and governments, and also noted the negative attitudes that can shape laws, policies and practices that stigmatise and discriminate against people with disability. The Royal Commission received 236 responses to the issues paper, and an overview of those responses was published by the Royal Commission in April this year, and it's on the website. A key theme emerging from the responses was that both people with disability and the broader community lack awareness of the rights of people with disability, which can enable violence, abuse, neglect and exploitation of people with disability. The submissions addressed concerns that the rights to the full access to education, health, legal services, employment, as well as other relevant areas was not reflected in Australian law. It was suggested that the current laws in Australia are outdated and inadequate and fail to acknowledge and respect the fundamental freedoms that people with disability should have, or provide adequate protection from systemic governmental discrimination, abuse, violence, neglect and exploitation. The importance of the CRPD in guiding transformation of law and practice was emphasised in the submissions, noting that the CRPD provides a human rights lens through which the character and impact of social wrongs, including marginalisation, segregation and exclusion of people with disability in all spheres of society, may be understood and addressed. It was suggested that the CRPD provides a blueprint and a framework through which to transform societies from a state of disability exclusion to one of disability inclusion. The submissions included suggestions for change and a way of translating Australia's obligations under the CRPD into Australian law, and we'll address some of those suggestions during the course of the hearing. The Commissioners, in June last year, you received a paper from the Australian Government described by the Australian Government as a background paper that set out Australia's position and interpretive approach to the CRPD. A copy of that paper is on the Royal Commission's website. The government said that the paper was intended to assist the Royal Commission and focus on the Australian Government's interpretation of its obligations under the CRPD. We will examine the approach taken by the Australian Government at this hearing. It's for these reasons that it was opportune for the Royal Commission to conduct this short hearing. This very short hearing over 2 days will examine the relevance and significance of the CRPD to people with disability in Australia. We will pose the question, how can international human rights law be more than a slogan and a symbolic gesture? What needs to happen to turn rights into reality for people with disability? So may I stress that over these 2 days, we will not seek to answer all of the questions. The purpose of this hearing is to understand how international human rights become part of Australian law, practices and policies, and the way in which the CRPD rights could be stronger and more effective in Australia. So can I turn to this hearing? As I said, you'll shortly hear from Rosemary Cayes and Therese Sands. Commissioners, at Public Hearing 3, you may recall that Ms Cayes provided us with a very clear and extremely helpful overview of the operation of the CRPD. So I'll not ask Ms Cayes to repeat her evidence from Public Hearing 3, but we will focus on the research paper. I will ask Ms Cayes and Ms Sands about a number of issues arising from their research. They will tell you the CRPD has modified, transformed and added to the traditional human rights. They challenge the suggestion that the CRPD does not create any new rights. And they will tell you that the CRPD has codified a human rights model of disability. This model rejects the historical treatment of people with disability on the basis of exclusion and segregation. That people with disability should enjoy their rights as citizens, and a person's disability is not a justification for the denial of rights. We'll have a break after hearing from Ms Cayes and Ms Sands. Then commissioners will turn to examine the awareness of the CRPD in the broader community and some examples about how people with disability can understand and know more about their rights. Mr Ian Cummings and Ms Rachel High from Our Voice South Australia have pre-recorded some evidence from a discussion with me last week, and they'll tell you what human rights means for them. Commissioners, we've also had an opportunity to talk to children and young people with disability, CIDA, and over the course of the coming weeks, we'll ensure that you can also hear about the experience of young people and their approach to human rights and the CRPD. Later today, you'll hear from Ms Natalie Wade. She is a respected legal practitioner with an established background in human rights law and advocacy, and she has particular expertise in disability rights and public law. She will tell you how the CRPD is relevant to her work, her experience of how people with disability and those people and organisations responsible for supporting people with disability apply the CRPD. And she'll also tell you about some of her law work and projects. In fact, her book was published late last week and she'll share her recent publication with you. Now, on the topic of advocacy, commissioners, in the interim report, you noted the importance of advocacy. You said disability advocacy is acting, speaking or writing to promote, protect and defend the rights of people with disability. Independent advocacy by people with disability plays an important role in implementing and monitoring the CRPD. You will hear about the work of the Disability People's Organisations, DPOs, and the Disability Representative Organisations, DROs. Damien Griffiths, June Reimer from First Peoples Disability Network Australia, FPDN, will tell you about the experience of First Nations people and the extent to which the CRPD addresses the rights of First Nations people with disability. They will be joined by Kelly Cox and Francis Kwan-Ferrant from People with Disability Australia, and you will hear about their advocacy at both an international and local level. We will examine the relationship between the range of international human rights laws, Chair, that you've described and those specifically concerning the rights of First Nations people. We've very kindly been assisted in the preparation for this hearing by a discussion with the Australian Federation of Disability Organisations, AFDO. AFDO and some of its members shared their experiences with the CRPD and the nature and extent of their advocacy work in various areas. They have highlighted the importance of DPOs and DROs being funded to be able to deliver effective advocacy services and support. They told us that people with disability may have no knowledge about their rights, and they've said that it's often until a person with disability is at a point of crisis that they may become aware of their rights. Commissioners, we need to address the relationship between international human rights treaties, like the CRPD and Australian law. And you'll hear later this afternoon from Emeritus Professor Andrew Burns, who's one of Australia's leading international human rights lawyers. He will tell you about the nature of international treaty law, how it converts into Australian law, and we'll talk to him about some of the concepts and interpretation of rights. And we'll also ask him about the Commonwealth's Parliamentary Joint Committee on Human Rights and its role in scrutinising proposed laws against international treaties, including the CRPD. Commissioners, you've noted earlier the models called dialogue models, and you'll hear tomorrow from Dr. Helen Watchers, OAM, the President and Human Rights Commissioner for the ACT Human Rights Commission, and Ms. Karen Toohey, the Discrimination, Health Services, Disability and Community Services Commissioner, about the experience of the dialogue model in the ACT. We need to look at other models and consider both the strengths and weaknesses of other models so that we can consider a range of perhaps innovative approaches for Australia. Well, Commissioners, it's well accepted that meeting human rights obligations on a day-to-day basis and in day-to-day life is not just the responsibility of governments. The private sector and business impact on the rights of people with disability in a wide range of areas: education, employment, the media, technology, superannuation, insurance, transport, housing, and access to premises. Specifically, the National Disability Insurance Scheme Act refers to the CRPD and other international human rights treaties. And Commissioners, as you are aware, the NDIS Act is a model that regulates government agencies, but also private corporations that provide supports and services to people with disability. Commissioners, you may recall at Public Hearing 13 that you heard that the directors of Sunnyfield Disability Services received training in relation to the CRPD and the relevance of the CRPD to the work of that particular service provider. So it is an important opportunity to consider how the CRPD rights apply in Australia with respect to corporations and businesses, in effect, the private sector. Over the past 20 years, there's been an increasing movement to hold corporations accountable if business decisions and their actions impact on the human rights of individuals. You'll hear tomorrow from Professor Justine Nolan, the Director of the Australian Human Rights Institute at the University of New South Wales, about recent developments for business and human rights, including modern slavery laws. Professor Nolan will address how a human rights approach has developed through the 2011 UN Guiding Principles on Business and Human Rights that was unanimously endorsed by the UN Human Rights Council. She'll explain how the guiding principles operate. Now, people with disability do not feature prominently in those guiding principles, but having said that, in 2017, the United Nations and the International Labour Organization released a guide for business on the rights of persons with disabilities to assist business respect and support the rights of persons with disabilities and benefit from inclusion. So we'll touch on some of the work done by the International Labour Organization. Then, Commissioners, the participation of people with disability in organisations, including government, corporate and the business world, is also an important consideration. The participation of people with disability is one of the core tenets of the CRPD. People with disability should have a seat at the table when decisions about them are being made. And you'll hear tomorrow from Christina Ryan, the founder and chief executive officer of the Disability Leadership Institute, about how the CRPD and a rights-based framework applies in the context of leadership. And particularly, she'll address Article 29 of the CRPD concerning participation in political and public life. And Commissioners, finally, there'll be an opportunity to hear from the Australian Government. We expect that you will hear from Sue Robertson, the First Assistant Secretary, International Division of the Attorney General's Department. Mr. Andrew Walter, the First Assistant Secretary, Integrity and Security Division of the Attorney General's Department, and Luke Mansfield, Acting Deputy Secretary, Disability and Carers in the Department of Social Services. We will ask the representatives of the Australian Government about a range of issues arising from the background paper and the implementation of the CRPD in Australia. The Government has provided answers to a series of questions that we'd asked them prior to the hearing. The issues that we will explore with the Australian Government officials will include the following: the steps Australia takes when it accepts international treaty law obligations such as the CRPD, the Australian Government's understanding of what the CRPD obligations would mean for Australia at the time it ratified the CRPD in July 2008. At that time, whether the Australian Government undertook a review of Australian laws and practices to determine what needed to be addressed when the CRPD obligations commenced. We will ask the Australian Government about its approach to interpreting and understanding the CRPD rights, including such concepts as what is progressive realisation and what is a margin of appreciation. We will ask the Australian Government about its understanding of and application of a human rights-based approach to address violence, abuse, neglect and exploitation of people with disability. We will ask about the impact of parliamentary scrutiny processes on proposed Australian laws that directly and indirectly impact on people with disability. We will ask the Australian Government how it has developed, if it has, a focal point and how that operates across the government. We will ask about the ways the CRPD has been incorporated into Australian laws, policies and practices, including the NDIS and the National Disability Strategy. We will ask the Australian Government about the ways it has developed awareness of CRPD rights, including education about human rights. We will ask the Government about how it includes people with disabilities, the DPOs and the DROs, in the way it seeks to implement the CRPD. We will ask the Australian Government whether it considers the CRPD rights apply to corporations and private sector entities, and if so, what it has done to date in relation to the private sector. We'll ask the Australian Government how it measures and evaluates its compliance with the CRPD within specific agencies and departments concerned with CRPD and more generally. We'll ask the Australian Government's views about the gaps in the protection of the CRPD rights in Australia. We'll ask about the responses to the CRPD Committee's concluding observations and its responses to complaints made to the CRPD Committee under the optional protocol. This is an opportunity for a person who has exhausted all of their domestic remedies to petition or make a complaint to the international body. And then finally, we'll ask Australia whether it considers the experiences of other jurisdictions should be considered to better protect, respect and fulfil the CRPD rights. So, Commissioners, I'll conclude by observing a comment made in response to the Rights and Attitudes Issues paper. The person who made the submission said this: the CRPD should become more than just an aspirational exercise, but something that is genuinely adhered to in day-to-day life. Commissioners, a human rights approach means that people with disability are entitled to voice their concerns and hold duty bearers accountable when their rights are not respected. For people with disability, a human rights-based approach affirms they are entitled to enjoy all human rights and simply live a life free from violence, abuse, neglect and exploitation. It is a right to be included. Commissioners, I'll conclude by reminding those following the proceedings about the protections for witnesses in the Royal Commissions Act. I've said, I think now on 15 occasions, Section 6M provides a protection to any witnesses and outlined the consequences for those who engage in any conduct that uses, causes, inflicts, or creates any disadvantage to a person on account of that person having appeared as a witness before the Royal Commission, given evidence or produced documents to the Royal Commission. Thank you, Commissioners. And we'll start by turning to Ms. Kayes and Ms. Sands.
Thank you, Ms. Eastman.
So they should come on momentarily. See Ms. Sands.
Good morning, Ms. Sands. We're just waiting for Ms. Kayes to appear on the screen.
Thank you.
There we are. Thank you both very much, Ms. Kayes, Ms. Sands, for coming to the Royal Commission to give evidence. We appreciate the assistance you're giving both now and on previous occasions. I understand that each of you will take the affirmation. Therefore, if you would be good enough to follow the instructions of my associate, who will administer the affirmation to you. Thank you.
Chair, I think that's all
Is that
been done before coming.
In that case, we don't need to do it. Thank you very much. All right, now, Ms. Eastman, I think we'll ask you some questions.
Now, Commissioners, you have in the tender bundle a copy of the fairly comprehensive CVs from both Ms. Kayes and Ms. Sands. So I just wish to briefly introduce them, and I'm keen to get into the questions. Ms. Kayes, may I start with you? Welcome back for the third time giving evidence in this Royal Commission. Can you hear me?
Yes, I can. Thank you.
And you continue to be a teaching fellow and senior lecturer in the Faculty of Law at the University of New South Wales.
Yes, that's correct.
But much of your work is taken up with chairing the United Nations Committee on the Rights of Persons with Disabilities.
That's correct, yes.
And you also are the chair of all of the UN treaty bodies. So you're the chair of the chairs, is that right?
That is correct. Unfortunate terminology, but yes, it's correct.
Thank you. And you have worked with Ms. Sands to produce the research paper for the Royal Commission back in 2020, is that right?
That's right.
Ms. Sands, can I turn to you now? And thank you for participating in the hearing today. You are presently working as the Research and Policy Coordinator for Ms. Kayes, as in her capacity as the Chair of the Committee on the Rights of Persons with Disabilities.
That's correct.
And you have also had a role working in a number of the disability advocacy organisations. From 2007 to 2019, you were the Co-Chief Executive Officer of People with Disabilities, Disability Australia, is that right?
That's correct.
And you've had a long history working in the disability sector and in disability advocacy.
That's right.
You've also participated in the preparation of the research report for the Royal Commission with Ms. Kayes.
That's right.
Now, I want to dive straight into the research report, which is on the Royal Commission's website. And in that report, you say those following, this is at page 9, that the social model was the catalyst for the shift in how disability is conceptualised, which has led to the translation of human rights in the context of disability embodied in the CRPD. And in your report, you set out that there's been different models in understanding disability. And you say that while the CRPD is based on a social model of disability, it goes further by codifying a human rights model of disability. And I wanted to start by asking you about that. Does that mean that the CRPD is a really different type of international human rights treaties to some of the other treaties that protect human rights? Who would like to go first? Maybe Ms. Kayas, I'll ask you.
Yeah, I'm happy to take that one, Kate. Look, no, it doesn't mean that the CRPD operates any differently to any of the other core human rights treaties. In their way, they all set out the way the power relationships between certain groups within our community operate. So the thematic instruments such as the International Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of all forms of discrimination against women, set out concepts around racism and sexism and identify the ways in which we as societies, as communities of nations, should operate as a means to eradicate racism and sexism. CRPD is no different, but what CRPD does is it addresses the concepts around what people discuss now as ableism, or if you look at it from a different perspective, disableism. And the social model of disability was the catalyst for a lot of that development, that conceptualisation. Now, the social model needs to be understood in the context within which it's developed. It emerged in the early 70s from activists within the UK movement, and a few of them were academics. And so from their academic background, they looked at and they considered how the phenomena of disability is operationalised within society. So we weren't talking about disability, or what it fundamentally is impairment, or even more fundamentally to that, it's about human diversity. So the diversity of the human condition and how that interacts with the way society is structured. And so what the social model does is it identifies and helps to understand that a lot of what people experience, people with impairments experience, are barriers that are within the social structures, not necessarily inherent just to themselves. And so the social model was about framing a way of understanding the phenomena of disability. And the reason it played such a big role in terms of the negotiations and the shift that's outlined within the CRPD is that what that understanding does is highlights and identifies the barriers and the discrimination that people with disability experience. And so it became a framework of how structures needed to, and states needed to transform to be able to deliver the rights of persons with disabilities.
Is that the case if we look at some of the earlier international human rights treaties developed in the 1960s, is there's no mention of disability specifically in those treaties. Has broader human rights served people with disability well?
Well, that was the fundamental point. Disability has always been part of the non-exhaustive framing of international human rights. So from the very genesis within the UDHR, the Universal Declaration on Human Rights, the forerunner to the international covenants and then the international conventions, sets out discrimination in terms of a non-exhaustive list, so a suggested list of personal characteristics, and then it includes other status. Now, disability had been addressed under the framing of other status, but disability and the experience for people with disability continued to demonstrate that human rights frameworks, international human rights law, wasn't succeeding in protecting and fulfilling the rights of persons with disability. Persons with disabilities were continually recognised amongst the poorest of the poor. They were segregated and isolated from social participation. And the cyclical relationship between disability and poverty was recognised, and that cyclical relationship that disability creates poverty and poverty creates disability just didn't seem to be able to be broken. So there was significant development of what's called soft law to try and address that failure of the International Bill of Human Rights and the other thematic instruments not being able to cut through in the disability area. But the soft law, because of its declaratory and consensus nature, didn't have any binding mechanisms to be able to have a much more significant impact with states to implement measures to be able to address disability.
Ms. Eastman, I'm sorry to interrupt, but I'm informed that neither Ms. Sands nor Ms. Caius had actually taken the affirmation. And I think if that's right.
All right. I'm sorry, Chair. My understanding is that all of the witnesses will be administered their oaths and affirmations before they come on to the live feed. If that hasn't happened, then we'll need to do that.
Yes, that's what I've been informed. Perhaps Ms. Caius and Ms. Sands can tell us whether you've taken the affirmation as preparatory to giving evidence today.
I've, indicated my preference for the affirmation, but
but you have you taken the affirmation?
I haven't as yet.
Okay, thank you. But of course, it's not your responsibility or your fault, but we must adhere to the form. So if you don't mind, I'll ask my associate now to administer the affirmation. If you'd be good enough to follow the instructions. I apologise for the interruption and the inconvenience.
I will read you the affirmation at the end. Please say yes or I do. Do you both solemnly and sincerely declare and affirm that the evidence which you have given and the evidence which you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Again, I'll ask Ms. Eastman to resume her question.
Well, that perhaps takes me to the next point. And one of the issues in drafting the CRPD was whether there should be a fixed definition of disability for this convention, or whether it should be left open to deal with evolving concepts. And can I ask you both about how and why would we need to define disability in the convention? Can we work with the convention and understand rights without a fixed definition? As you know, lawyers like everything to be defined.
The debate around the definition was really strong at the convention, and whilst it was a strong theme that went through the convention negotiations, it was also very divided on whether there should be one or whether there shouldn't be one. Now, the problem with definitions is definitions can either include or they can exclude. So the convention needed a way to be able to address a concept that was about human diversity. And so a lot of the discrimination that people with disabilities experience is because of arbitrary lines drawn about the notion of human diversity. So we operate as a society with this concept that there is this able norm, that there's this state of being, this state of the human condition that is normal. And the further you move away from that, or if anything's different, that it is seen as not normal or abnormal. And these are very arbitrary lines that are drawn, and they will be very different in different states and different countries. And so whatever way you tried to frame a definition for the convention, you were going to exclude people. And there were states, I will be quite honest, it's not an international secret. There were states that were actively trying to get a very narrow definition so they could exclude very specific diagnostic groups. And so trying to get it as broad as possible was about going back to the roots of what the social model is about and recognise disability as a phenomena that stems from the interaction of impairment with the social environment. And what that meant was recognising that that environment could change. So the concept and the scope of disability will change, and that it was evolving. And the preamble uses that, the preamble and the purpose in the convention use that concept of disability being an evolving concept. And what we understand disability in terms of Australia in 2021 will be very different to how the concept of disability is understood in 20 years' time or 50 years' time, or how it's understood in Zimbabwe in 2021.
So related to that, you've said in the report that the CRPD is not static, but reflects the nature of all international law, which is progressively adapted to address new situations and realities over time. Mm-hmm. When you talk about the CRPD not being static, does that mean that the nature of the rights change, or is it the way in which the existing rights apply in particular situations as those situations arise? And I'm happy, Ms. Sands, if you want to talk about this. Or
yes, I can.
To ask Ms. Case, do you want to talk about that sense of it not being static, and does it mean new or different rights, or what does it mean?
It doesn't mean new rights. It's about recognising that circumstances and situations in political, cultural and social context change and are constantly changing, and that governments or states parties, those countries that are need to meet, to be able to apply measures to meet their obligations under the CRPD within that. So this is the case for all international human rights law and the application of that law. The committees that monitor the law recognise the different cultural, social, political contexts of all countries when they're doing that. They understand there are different resource constraints, different factors that impact on the development of measures and the implementation of those measures to meet human rights. So the rights themselves don't change. I mean, I suppose an example of this is when we consider women's rights, and we consider that previously the legal capacity of women was limited. They needed to change their name when they were married. Often their husbands controlled inheritance. and rights to property, legal guardianship of children, etc. There are a number of societal understandings of how women were conceived in society. Now, that has largely changed, and it's expected that governments will identify and implement measures to address that situation, that we no longer accept that women would be denied their legal capacity in relation to men, or that men would make decisions for women, for example, etc. So generally speaking, in terms of the CRPD, we would expect a similar thing for states to recognise that they need to consider how to apply measures over time to progressively meet the different realities for people with disability that they are trying to address in terms of their rights.
To ask both of you, does that also mean that when we look at the state's obligations or government's obligations under the CRPD, does it mean that governments are always striving to look at ways of better protecting rights? Or is it just a matter for the government to say, we've signed up to this convention, we've had a look at our rights for people with disability in 2008, everything looks quite good, tick, convention done? Ms. KS?
Well, no. I mean, things conceptually change. I mean, yes, there is a degree when you look at some of what are understood as the negative rights. So they're the rights of non-interference. But even rights of non-interference these days are recognised as holding positive duties on states. And so the positive duties to ensure the exercise of certain human rights, new situations will emerge and states will need to respond to them. Different groups will come forward, and the discrimination that they experience and the inequality that they experience will be understood more clearly, and so states need to respond to that. Climate change is an example. It's changing the nature of our environment, and so human rights will morph and change with that experience. As economies change, the social structures change, and so there could be new emerging areas of inequality and discrimination that need to be addressed. So human rights is not a static thing. Our societies are not static. We as cultures are not static. We're not time locked in that sense. So whilst the rights of non-interference, so not interfering in the legal, not placing legal impediments in front of groups based on personal characteristics may be static, and that you should basically, once you repeal a law stopping people from particular groups voting, once you repeal that law and avail the right to vote, you should leave it. Yes, that does have a static element to it. But us as societies, we are not static, and so human rights should also be seen in that way.
You have said in the report that the CRPD must be understood as the sum of its parts, with all of its components interacting with one another rather than in isolation from one another. And then you give some examples. And am I right in understanding from the report that if you consider the CRPD as the sum of all of its parts, then you have to be mindful of how all of those rights work together when you're looking at systems and practices and policies to implement the CRPD rights?
Well, like any policy area, things don't operate in isolation. So for you to be able to engage with the health system, you need to be able to exercise, a variety of aspects of your life. So legal capacity is one. You need to be able to consent to certain medical interventions. You need to freedom of movement. You need to be able to get to the health system, to interact with the health system. There are, accessibility issues in terms of, being informed about the health system. And so you can't look at particular areas in isolation and expect people to be able to participate effectively within those areas. So looking at rights more holistically, it comes back fundamentally to the, human rights are indivisible. Well, they are indivisible. You can't look at rights in isolation to each other.
Is it right in understanding then that once you consider the CRPD as the sum of its parts, what sits right underneath all of that is these concepts of equality? And in your report, you've addressed the different ways in which we understand equality and highlights transformative equality as a particular feature for the CRPD. So can I ask you some questions about that? When we're talking about equality, there's lots of different ways of describing it. There's formal equality, which is if we treat everybody exactly the same way, then people are equal. Then we have substantive equality, which recognises that if you do treat people exactly the same way, but people are different and start from different positions, actually treating people the same way will be not achieving equality. So substantive equality says you treat people differently, perhaps to achieve a same outcome. That's substantive equality. In this area, you've said there's a third way of looking at equality, which is transformative equality, which is about changing the structures and systems with a variety of positive measures. It dismantles existing power relationships. And in this sense, transformative equality can be viewed as addressing the underlying power relations that underpin ableism. All right, so I need some help in understanding transformative equality. So can I ask you that first? And then if it helps, what does that look like in a practical setting?
I need some help in identifying the page.
So this is page 29.
Thank you.
And over the page to page 30 in the report. Who would like to take the question on transformative equality and how we should be thinking about that in a very practical way for Australia implementing the CRPD rights?
I think we've both got, stuff that we can contribute to this. I might start, if that's okay, Therese.
Sure.
I suppose if you put it that we see it as a third way, I think it's a way of understanding substantive equality as it's been understood in a disability context and within a CRPD context, in the sense that, it gives us what the committee has talked about in terms of a human rights model of disability. Now, transformative equality, a bit like substantive equality, comes back to an academic exercise of trying to break down the component parts and understand how social relationships work and how we can work with them to achieve certain outcomes. So substantive equality has been looked at by a legal academic by the name of Sandra Fredman from South Africa, and she's She's developed a model or a theory around substantive equality being based on 4 core elements. And those 4 elements include a redistributive element to address socioeconomic disadvantage, a recognition dimension to combat stigma and prejudice and recognise human dignity and intersectionality, and a participative dimension to reaffirm the humanity of people through social inclusion and political voice, and a transformative dimension to accommodate difference and structural change to make space for difference as a matter of human dignity. Now, there's various ways that you can look at that. For me, to keep it in my head, the way that it works for me is that if we address redistribution and that we give recognition and combat stigma, and people do have a voice, you then can drive the transformation that's required to achieve human rights. But it's essentially just a framework for understanding about how to achieve equality.
Do any
So-
of our, sorry to interrupt you, go ahead.
And I mean, as Therese would tell you, the fundamental underlying thing about this is that it becomes a relationship with non-discrimination and inequality.
Ms. Sands, can I ask you about that and whether there are any Australian laws that incorporate that concept of transformational equality?
Look, just to sort of add on to what Rosemary has said, and just to say that the Committee on the Rights of Persons with Disabilities, in their general comment number 6, have a section on the human rights model of disability and what they call inclusive equality, which is really transformative equality, but they use the term inclusive equality. So the way that I would see it is that you have to understand transformative equality as being underpinned by that human rights model of disability. That is, that there is a recognition that impairment is part of human diversity, and it is, and as the CRPD says, is no longer the basis, can no longer be the basis for the denial or limitation on human rights. So all human rights apply equally to all people. And so when you're looking at that concept of equality, that means that those elements that Rosemary pointed out, the transformative aspect of it is critical in recognising that particular law, policy and practice frameworks don't actually are the basis for the denial and limitation on human rights in Australia. And so they're not geared towards transformative equality. So, for example, guardianship systems, mental health laws, etc., all limit the human rights of people with disabilities. So they limit them based on impairment. And that would go against transformative equality. That would demand you to look at those systems and say, well, that's no longer applicable under the CRPD to deny or limit human rights. So we need to apply recognition before the law and decision-making, non-coercive mental health treatments. We have to apply that equally to people with disability. And so we need to look at our systems. How do we change them to actually change those structures and those underlying power relations that create and diminish those rights? It's a challenge for states to look at existing arrangements in this way, and it's not an easy task. But that's what transformative equality is demanding, is looking at underlying structures, changing those structures to ensure that there is no denial and limitation on human rights for people with disability. In terms of whether that potential laws or policies in Australia that build in that notion. I think that perhaps the National Disability Insurance Scheme Act does have that potential because it is underpinned by several human rights treaties, including the CRPD. So it does acknowledge that human rights are critical to providing disability supports, and the way we do that in Australia. Some of the implementation and application I'd probably have some criticisms of, but I think the aim of that act is to attempt and aim to transform systems and underlying power relationships so that people with disability have control over their supports and services.
Ms. Sands, you mentioned limitation on rights, and I want to ask you both about that. We often see in human rights treaties, particularly those dealing with civil and political rights, that the rights are not absolute and can be limited if there's a law and it's proportionate and it's for a particular purpose. We don't see that model of rights limitations in the CRPD. And Ms. Sands, are you saying that the rights in the CRPD are not subject to any limitations? Can I just ask you to explain that?
No, I'm not saying that. All human rights, unless they're absolute rights, can be limited for a legitimate purpose, and as long as they're proportional to that limitation. That applies across all international human rights. What I'm saying about limitations is limitations on the basis of impairment. So it's about the limitation is not a legitimate objective purpose. It is based on impairment. So when I was speaking in relation to, say, the guardianship system or mental health law provisions, so guardianship limits the autonomy rights of people with disability. It is allowable and legally allowable for third parties to consent to medical treatments, for example, or consent to different living arrangements, etc., under guardianship tribunals, depending on the powers that are provided to the guardian. And under mental health laws, third parties can consent to treatments for people with psychosocial disability in mental health facilities or in the community. And it's a limitation based on those impairments. So when I'm talking about limitations of human rights for people with disability, I'm talking about the limitations based on impairment. But Rosemary would be able to explain perhaps more fully in relation to limitations of human rights more generally.
Ms. Case, is there anything you want to add to that? Because I understand that a person's impairment itself is not the basis for the limitation, but that does not mean that the rights in the CRPD should be considered to be absolute rights in the sense that there's no limitation. Is that right?
That's, CRPD carries with it the framework of international law as it's been established through other instruments as well. So if you go back to the ICCPR in Article 4, where it establishes basically absolute rights, so recognition before the law is an absolute right, and that cannot be derogated in even in situations of state emergency. So when you're trying to differentiate between CRPD and other instruments, what you need to do is consider, in light of the purpose and objective of the CRPD, whether the limitations that are being placed on something are proportionate. And so it's a measure not of proportionate in terms of how we understand other instruments, but proportionate in terms of how we understand and whether it's a legitimate policy objective given the purpose and objective of the convention.
Jumping in there, does that mean that it's very important when we're looking at the CRPD that we've got a clear understanding about what the particular rights mean in the first place?
Yeah.
And that task of interpreting and working out the meaning of rights could have a bearing on any concept or application of limitations as you've described them. Would that be an appropriate starting point?
That would be a very appropriate starting point. I mean, that's where the committee would start as well. I mean, and the committee can push back and other states can push back in terms of a state's party's decision to limit rights in any particular way or derogate from rights in a particular way, citing 4.2 from ICCPR as the basis of their Article 4 of ICCPR as the basis of their limitation.
I'm conscious of the time, and we will ask the Australian government about its interpretive declarations. And that is a process of saying this is how we interpret the CRPD rights as Australia. And then built into that interpretation is a form of limitation. Is that right?
Yes, it could be read that way.
Is there another way of reading it?
I think for the Australian government, sorry, Rosemary, to jump in, but I think for the Australian government, their interpretive declarations, they are claiming that they are meeting their obligations under the CRPD, and the way they interpret the CRPD under those particular articles 12, 17 and 18 is consistent with the CRPD. That's how I understand their argument.
I'm mindful of the time, and I think I've got a few questions to ask, but I might just check if the commissioners have got any questions.
Well, I think first we might check, whether any of the council who got leave to appear have any questions. And specifically, are there any council present who wish to ask either Ms. KS or Ms. Sands any questions? I'll take silence to mean no. Very good. In that case, I'll ask first Commissioner Ryan, do you have any questions?
Yeah, just one. Look, I'm just a little unclear. Would you take the view that, because in some notes we've got, it suggests that you believe that the CRPD codifies a social model of disability. Would you take that to be true?
I'm happy to go with this unless you'd like to, Therese.
Well, the only reason I
That's
ask...
okay.
Okay.
Oh, sorry, you.
Well, the reason that we put it like that is that because the way the CRPD is addressing disability discrimination, the social model frames what disability discrimination is. It gives us an understanding of how disability discrimination occurs. So impairment being the functional trigger for the discrimination. So it's based on impairment, and it's the interaction with the social environment, whether it be social
I understand
structures
that.
of attitude.
I'm mindful of the time. I just wanted to get, do you agree that the convention codifies the social model? The reason I ask is in your research paper, you've actually said that the CRPD entrenches the impairment model of disability. So I just wanted to find out which was true, and does it matter? I'm not a lawyer, so I don't understand, but does it matter whether or not the CRPD either codifies or entrenches the impairment model of disability?
I don't think it does, because the way the articles are structured is to be able to address discrimination and inequality, and that's how it's framed in terms of a social model.
Yeah, and it's clear in Article 1. Article 1, the purpose of the convention, the wording there actually outlines the social model, and also makes it clear that all human rights apply to all people with disability, which is the additional human rights model component for the social model. It takes the social model further, I should say.
Yes. Commissioner McEwen, do you have a question?
Thank you, Chair. Yes, to both of you, and thank you for your evidence. On page 9 of your report, you've stated that, and I'm not going to read out precisely what it says, but you've stated ableism is still entrenched in legal policy and practice frameworks which continue to segregate people with disability from the general population. Can I confirm that you consider that the CRPD required Australia to dismantle segregated systems such as special school children workshops in order to realise the necessary transformation or social transformation required by the CRPD?
Yeah, well, okay, I'll start. The segregation is basically established within international law as being impermissible. And the segregation based on impairment should be recognised in the same way. So if you see segregation as impermissible across other areas of international law, and that impairment through CRPD is recognised as part of that suite of international law, then yes, breaking down and removing segregated settings and mechanisms from social infrastructure is critical, because it's not seen as part of a permissible human rights framework.
Yes. Oh, thank you. I don't know whether Ms. Sands wanted to add to that, but thank you.
Thank you very much.
Look, I would just agree
I'm
with
sorry.
Rosemary. Thank you, Commissioner. Thank you.
Thank you.
Can I?
Is there anything else?
Yes,
Ms.
I
Eastman?
just wanted to make sure that commissioners had sufficient time to ask questions. The final question for both witnesses is there one thing that you think could be done to better protect the CRPD rights in the Australian setting, be that a model or a policy initiative?
Australia's history of having a very ad hoc and piecemeal framework around protecting human rights needs to be addressed. We've got no uniform mechanism by which the suite of human rights, as they apply across our community, so not just the International Bill of Human Rights, the Universal Declaration and the International Covenants of Civil and Political Rights and Economic, Social and Cultural Rights, but also the thematic ones of race and women and children and disability. Holistically, there is no mechanism that embeds them into our law. So policymakers, the judiciary, have reference to them as a matter of course. What we've got at the moment is a piecemeal ad hoc approach that leaves gaping holes for the denial and violations of human rights to occur. So mechanisms that can establish CRPD as part of our domestic framework, I think are critical. We have talked for many years around a Bill of Rights or a Charter of Rights, the same as other common law countries such as New Zealand, the UK, Canada, probably most famously, where it started with a statutory Bill of Rights that then became a constitutional Bill of Rights. So some form of mechanism. We have some charters in state jurisdictions, but that doesn't give universal protection over all civil and political rights and social, economic and cultural rights. And it also doesn't give a national coverage as well. So I think we do need a mechanism like a Charter of Human Rights to ensure that human rights are taken seriously across the leadership framework and the policy and judicial framework within Australia.
Thank you. Ms Sands?
Look, I absolutely support what Rosemary's saying. I could probably just add to that I think 13 years after ratification, Australia still continues to maintain its or retain its interpretive declarations. And as we point out in our report, those interpretive declarations largely maintain the status quo in how rights are applied to people with disability, which stifles reform and the necessary reform required. I think Australia has a significant opportunity to be a leader globally and in the region nationally if it withdrew its interpretive declarations and fully embedded a human rights model of disability or understanding of disability into its law, policy and practice frameworks. And that means by genuinely looking at its systems and structures and seeing where they do limit human rights on the basis of impairment and looking to the developed jurisprudence over those 13 years from the Committee on the Rights of Persons with Disabilities through general comments, concluding observations, including to Australia and to other countries, the findings of the committee in relation to individual communications or the complaints that have gone to the committee, including in relation to Australia, as well as looking at other states or countries that have embraced reform. Australia could join that leadership group. So, for example, Ireland has a Assisted Decision-Making Act. It has developed policy and practice around supported decision-making for people with disability, and that act is due to come into force next year. Other countries have also abolished guardianship arrangements. We have the World Health Organisation that has recently released guidelines.
Ms Sands, can I just jump in there? We will look at some of the other models. So can I just understand your evidence that in terms of what Australia could do, you sort of build on that model of equality being part of Australian law, practice and policy. Is that right?
Yes, that's right. To remove the interpretive declarations and to engage with the human rights model and the transformative equality that is understood as part of the CRPD.
Can I thank you both for your evidence? Commissioners, I'm not going to formally tender the Royal Commission's research report. It's available publicly on the Royal Commission's website. But could I tender into evidence the curriculum vitae for Ms KS and Ms Sands? And also we've included in the tender bundle an article prepared by Ms KS and Mr French called Out of Darkness into Light, Introducing the Convention on the Rights of Persons with Disabilities, published in the Human Rights Law Review in January 2008. If those documents could respectively be marked Exhibits 18.1, 18.2 and 18.3. And Commissioners, that concludes the evidence, and I'll take full responsibility for running over time, but if we could adjourn now for 20 minutes.
Yes. Well, first of all, I'll admit into evidence the documents you have identified respectively as Exhibits 18.1, 18.2 and 18.3. I add on behalf of the Commissioners our thanks to both Ms KS and Ms Sands for coming to the Royal Commission to give evidence and for the contributions you have made. We very much appreciate the evidence that you have given and the assistance you have provided to the Royal Commission. Thank you very much. We'll adjourn now until 11:45 Eastern Summer Time.
Thank you.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Ms East.
Thank you, Commissioners. Last week, I had the opportunity to talk to Our Voice SA and two of the members of Our Voice SA. Our Voice SA is a group of people living with intellectual disability who meet once a month to talk about issues that are important to them. They speak out about things that matter on the day-to-day lives of people with intellectual disability, and they provide training in self-advocacy and advocacy.
I'm sorry, I think we've lost transmission. I'm sorry. Jack, I assume nobody else can see us or hear us. Hear us? Well, that's 1 out of 2. That's good. So do we need to adjourn until this is fixed?
Sorry.
Sorry?
Yes.
I'm not sure whether people who are not in the Sydney hearing room can either see or hear us, but we have a difficulty with the system, so we'll adjourn for a few minutes hopefully to get it fixed.
The Royal Commission is adjourned.
Yes, please.
Commission is resumed.
Yes, I'm sorry for the interruption. Yes, Ms. Eaton.
Commissioners, I was saying that we had an opportunity to meet last week with Our Voice SA. It is an organisation for people living with intellectual disability. They meet once a month to talk about issues that are important to them. Our Voice SA speaks about matters that impact on people living with intellectual disability, and it provides training and advocacy services, both in terms of self-advocacy and general advocacy. And the two people who we spoke to last week is Ian Cummings. He has been a self-advocate for over 25 years, and it's developed into a passion for him. He first spoke up about moving into his own home, and Ian believes everybody should have the opportunity to have a say and make their own decisions. And he's the chairperson of Our Voice SA. And he's joined by Rachel High. And may I say, she's quite modest in this video, but she is a very accomplished actor and dancer and performer. And you can see more about her story on a little piece on the internet called the 100 Leaders Project. But they're going to tell you about what rights mean for them and the work that Our Voice SA does. So we'll start that video now. I've got with us, talking to the Royal Commission today, Mr. Ian Cummings and Ms. Rachel High. So I'll start by introducing each of them and asking each to tell us about themselves. So we're going to use first names. Rachel, can I start with you?
Of course.
All right. And what can you tell the Royal Commission about yourself?
Well, I migrated to Australia from London in 1978.
You were born in London
Yes,
and you moved to Australia?
in 1978.
And did you move to Australia with your family?
Yes, I did.
And where in Australia did you move to?
Port Augusta.
Port Augusta. And have you lived there forever?
Yeah, I've been there from a year old to 19 years old. So
And what happened when you turned 19?
I got employment with the Rivers Dance Company at the time.
And tell me about that job.
Oh, it was always dance. I was always very much interested with the theatre, with dance, and wanted to fit in with something, fit in an area that I was interested in. So that's how I got that job, really. So.
And are you still working in dance and the theatre?
I am still working in theatre. I'm getting a degree in theatre from Flinders University.
Yeah.
It's December, so it's been building up ever since. So.
And I understand you're an actor.
I am an actor, yes.
And what have you been doing in your acting jobs and career?
Well, part of it was in a film called One Night at the Moon as an extra. It was a Rachel Perkins film, so yeah, that's what I did as an actor, and been performing ever since. Loved it ever since.
And how did you get involved with Our Voice South Australia?
Good question.
You applied for the job.
I applied for the job.
And what do you do with Our Voice SA?
I went underneath training in the peer section, peer mentoring section. So that's what I had to do. So to help, I think, help facilitate, I think is the word for it. So help facilitate the meetings and all that. So
is it a good job?
It's a great job. I'm loving it. I really am.
I might come and ask you more about your job in a moment. So Ian, can I ask you some questions?
Yes.
Ian, what would you like to tell the Royal Commission about yourself?
I was born in Peterborough, country town. I live in Echuton till I'm 19 years old. When I moved out, I started at Equal Whites, and you learn stuff about Equal Whites and all that. And I started a committee up at Our Voice SA in the 1970s.
Yeah.
As people with intellect disability, learning disabilities.
Yeah.
Richard Brueggemann, you've heard of the name Richard Brueggemann for South Australia?
We have. Richard Brueggemann came to the Royal Commission and gave some evidence when we had a hearing in Adelaide a few months ago. So the Royal Commission's met Richard Brueggemann.
He's our patron. Cobb, how I first started that off, Cobb, 1970, there's a committee in that Our Voice Australia. Mm-hmm. And I was asked by the South Australian Rep on that. I started Our Voice up because they wanted somebody from South Australia. I started our committee up, Our Voice. I know the system inside out. Why I start committee up, right? Hear from other people. They come on board and they talk freely about their lives and all that. And people starting to learn. We have 2 members on our board. Just will not talk. I wouldn't talk to anybody at all. Now, one of them's won an award in South Australia, and the other one works for Performance for Our Voice. Cobb, she wouldn't. Before that, she wouldn't talk to anybody. Since she joined Our Voice, you can't shut them up.
So Ian, how do you help people find their voice? Rachel is an actor and has worked in the theatre, so Rachel's used to talking. But for other people, they might not be comfortable talking. How do you help people get their voice, as you say, so they'll talk and you can't shut them up?
I'm classed as an advocate. I'm classed as an advocate. I've got standards to go by. I help people along, but they have the final say. And I've got contacts. If I can't go any further, I handle them. If they can't do anything, I go through the court system.
Right.
Help other people, help them along, but can't talk this, don't want to talk in front of people. I've got to get yourself in trouble and all that.
So you help them.
Yes.
The topic that the Royal Commission's talking about today is about human rights. And I wanted to ask you, what are human rights for you? What do human rights mean for you?
To me, I spent time in an institution when I was 19 years old. I never had any rights. When you live in institutions, that you got rules you have to follow. When I moved out, I learned the hard way. I pay my own bills. I've got people for milk breaks. I don't have to tell what time you have to be in, what time you have a shower, what time you have to be home and all that. Part of your rights is part of that. Do what you want to do out in the community. You got the same rights like anybody else that hasn't got a disability at all.
Rachel, what do human rights mean for you?
Well, the right to be independent, like in your own home and in your own community. I see that as a human right. The right to explore, the right to be who you are, not what you are.
How do you get human rights?
By it's a learning thing really with human rights sometimes. So some people can learn about their own rights and how they actually get that, from other people. So like around them, like people that you're a neighbor with or something like that. You actually let me think. That's how you get it, that's how you get the human rights. Sometimes, we're like going to a library or a museum or something. It's a right to explore, right to learn. That's how you get it. You learn that's how you get those human rights. You learn to obtain that. So,
Ian, what do you think about where and how you get your human rights?
You learn when you move out, you live in the place for so long, when you move out in the community, you learn how you do everything for yourself. You don't lie on anybody else. Part of your rights. Teach other people, have workshops and all that. You do workshops, they teach people, but how do you get your rights? You learn yourself. You don't lie, you lie on yourself. You don't lie on anybody else at all.
Who needs to know about human rights for people with disability? Who should know about them?
People with disabilities learn the right, these slightly change. People with disabilities have to know about equal rights, in some areas it's still not. Some areas are still not learned. People don't know they've got equal rights till somebody tells them. And that's always the hardest part. If they don't pick disability, don't know about, they won't learn anything, would they?
Rachel, who needs to know about human rights?
Everyone needs to know about human rights. Everybody needs to know about that.
How do we help people learn about human rights?
Workshops.
Yeah, okay, workshops.
Yeah.
Yeah, workshops, that's right. Yeah, it's the education of being, learning about how to obtain their own rights.
Role modelling.
Role modelling, sorry.
Role modelling.
Yes.
What do you do in being role models to help people learn about their human rights?
Doing the workshops to learn about their human rights, what they have the right to go, where they have the right to be. That's how you learn, really, the workshops of that.
What can you tell me about the workshops?
Go to a workshop, Cobb. Any workshop, you got whole pie, you got Debbie and Ellie, they do the up of the workshop. As a role model, so they teach other people in the disability area about equal rights and all that. That's a role model. You come as Cobb, I'm a mentor, and now you're a role model for everybody else in the disability area. You learn other people with disabilities, and that's why you learn about you teach other people with disabilities about human rights and all that. That's why they have workshops for. How come when we get our funds for part of our NDIS funding, right? Go out in the community and teach people about equal rights and all that. We do workshops around Adelaide. We're teaching other people with disabilities all about it. More people know about equal rights and all that. That way they learn. And they teach other people, best part about it, they can help the other people they live with and out in the community too. You talk on their behalf and help them along too. That's it. That's part of it. Doing the workshops.
What about for people who don't have a disability? Do people who don't have a disability need to know about human rights for people with disability?
Yeah.
Yes, they do.
Yes, they do in a lot of ways, but people haven't got disability, they know they know about the rights anyway. But when you got a disability, a lot of people don't know you got the same like anybody who hasn't got a disability at all.
So how do we help people who don't have a disability to learn about the human rights of people with disability? What should they be learning?
Like workshops, and you do workshops. And then people go to workshops and they learn about equal rights and all that. If you don't do a workshop, they wouldn't know. A workshop's in there, you teach people haven't got a disability, they got rights like anybody else has.
Do you think people who don't have a disability need to learn from people who do have a disability?
Yes. Yeah, Cobb.
Why is that important?
Cobb, a lot of people aren't. Cobb, when you got a disability, people know your rights, but people haven't got disabilities, what? They don't really understand what it's like for a person living with a disability at all. And it's different. When a ball gun change, they can be in a car accident and all that. They come disability. And that's always the hardest part. Like us, we live on a daily basis. People haven't got disabilities. When they come disability, their life just changes altogether.
Is it about helping people understand about life with a disability?
Yes, in a lot of ways, yeah. Bob and peers, troops and all that, a lot of peer troops. That's why they learn. Everybody's got a story to tell. But disability. You haven't got to teach people who haven't got a disability, right? They might have stories down the track. They might have stories down the track, and they like everything else.
So one thing about people with a story to tell is sometimes in helping people to feel confident to tell their stories and to speak up.
Yes.
That's a lot of what you do at Our Voice SA, is to help people speak up. Is that right?
Yeah, yes.
And how do you help people speak up?
Give them a voice. With our voice, other organisations, right, they've got somebody to answer to. Our voice is cooperated. We don't answer to nobody. If we got an issue of this person with disability wants to bring up somewhere, we've had cases and all that. It's just have to bring up, but we don't answer the organisation or nobody at all.
Rachel, what would you like to see Australians do to do better for human rights of people with disability? What should happen in Australia?
I have to think about that.
That's okay.
You're speaking at the conference.
Sorry?
You're speaking at
Well, I'm actually speaking at a conference about mental.
Yeah, you can tell her what you're speaking about.
I'm speaking about stereotypes in the conference. Yes, and what how detrimental stereotypes are to people with disabilities. I'm talking about that, in general. So I think that should be addressed as well sometimes.
Stereotypes?
Stereotypes should be, I think they should be addressed and heard, and for other people in whatever state they live in to understand about that, to learn about that, and how detrimental it is to people like me, for example. It's the same like me. It is for other people because like labeling. It's called labeling. So I think it's important to, for people to hear that and to learn from that as well. So about that kind of form of act.
Ian, what would you like to see for Australia?
I want to see more people with disability have more of a say. You know why? Everybody makes decisions for you. And half times not the right way, but at the moment, not enough. They don't ask people this, they don't go to the resource. People with disabilities at all. They always have people, work people with disabilities and all that, but I like to get more people with disabilities above or have a lot more.
Is there anything you'd like to tell the Royal Commission about what should change to do better for the human rights of people with disability?
Have more people around Australia, more people learn about the rights. Let them speak up. And that's why they learn about the rights. Because you do workshops. Only thing about it, you learn that yourself. And they got more confidence in themselves, and they won't be scared to speak up and say something.
Also, good support workers are important. They need to know the rights, don't they?
Because you learn, that's why they learn. Because more confidence to speak for themselves. Like my committee, they got rights. They speak up for themselves. They speak up for everyone else on the track. That's why they learn. And everybody who hasn't got disability, that's how you teach people and all that. You learn that you have to learn it yourself. You do workshops and all that yourself, but you have to do it yourself to learn. It's a lot easier down the track.
Well, thank you both very much for talking to the Royal Commission today and telling us about the work of Our Voice SA.
Of course.
The work you do to support people with disability to have their voices. Thank you very much for talking to us.
Yeah, thank you.
Thank you.
Commissioners, I'll shortly tender that video, but there's a short video that Our Voice SA have prepared to help people understand their human rights, and we had a discussion with them and they'd like us to show this very short video. Thank you.
Human rights, what it means to me.
Human rights is everyone got a right.
People have rights and freedom and what their own conditions.
I've got a right to work as in everyone else.
I have right what to eat for breakfast, what to eat for lunch.
And also I got a right to live in the community, to volunteer.
I think that's right what to wear and when and how.
And I got a right to have an education.
And I got right go to bed, I got right go to Christmas shop, go to shopping mall, all the right in the world.
And had no violence and abuse.
Do not do anything that it might harm you or hurt you. It's okay to say no.
And most important one of a lot is to be loved and cared by somebody.
You have to know the rights to make decisions.
Sometimes people don't know where to start, or they don't believe in themselves because someone always told them this is how you got to be and this is how you act.
It doesn't matter about your disability, you can do it.
Self-advocacy would be a good starting point to go to them, and also some things like Shasha with the intellectual disability, Purple and Orange for their service and our voice. They are good because they teach you to stand up for your what.
You can have that right. It's very important, people.
We thank Libby Crawford and Gavin Berner for sharing what human rights means to them. Libby and Gavin are members of Our Voice SA. Our Voice SA is a self-advocacy group for people living with intellectual disability. Our Voice SA is supported by JFA Purple Orange. Our Voice SA 0883738327 www.ourvoicesa.org.au. JFA Purple Orange 0883738388 www.purpleorange.au.
Thank you, Commissioners, and thank you to Our Voice for sharing the video. Could I tender both those videos and ask you to mark them Exhibit 18.4, that's Ian Cummings and Rachel Hy's pre-record, and 18.5 for the Our Voice SA human rights video. Thank you,
Yes,
Commissioner.
both of those videos will be admitted into evidence and given the markings indicated by Ms. Eastman.
Commissioners, our next witness is Natalie Wade, and I apologise for the delay in keeping Ms. Wade waiting, but I hope she'll come into the hearing room now.
And may we assume that Ms. Wade has taken the oath or affirmation, as the case may be?
I think we can assume that.
Very good. Yes, I think we have Ms. Wade on screen. Thank you very much, Ms. Wade, for coming to the Royal Commission to give evidence today. We'll start by Ms. Eastman asking you some questions. Thank you very much.
Ms. Wade, thank you for returning to the Royal Commission. You gave evidence at Public Hearing 5 last year. So can I confirm you are Natalie Wade?
That is correct.
And you've provided your address to the Royal Commission?
I have.
And you are a legal practitioner?
That's correct.
You've provided to the Royal Commission your CV, and you've told the Royal Commission that you have an established background in human rights law and advocacy, and you have particular expertise in disability rights, public law and evidence law. Is that right?
That's correct.
And you hold qualifications as a Bachelor of Commerce, Bachelor of Laws from the University of Adelaide?
Yes.
and you also hold a Master of Laws from the Australian National University.
That's correct.
You are the founder and principal lawyer of Equality Lawyers.
I am.
And that's a law firm that you established in July 2019.
That's correct.
And much of your work is to provide advice and representation for people with disability, their families and supports. And you cover civil, administrative law, but essentially you focus on the everyday legal issues that face people with disability.
Yes, that's right.
Now, I mentioned this morning in opening that I think as late as Thursday or Friday last week, your book has been published. And if the commissioners indulge me, the commissioners will find a copy of Ms. Wade's book behind tab 7 in the hearing bundle. And it's called Disability Rights in Real Life. And I'll just put the cover of the book up. And you have very kindly agreed that the Royal Commission could tender this book into evidence. And that means that the book will be available to be accessed via the Royal Commission's website once it becomes an exhibit in the proceedings. Can I just check that you're agreeable to that approach and we're not encroaching on any commercial interests or rights on your behalf?
I confirm that I hold the copyright to the book and I consented for that to be so, and I appreciate it happening.
Thank you. That's extremely generous. And commissioners, you'll see it's a very extensive publication that details in a very accessible form the nature of rights and the relevance of these rights in an Australian setting. And that's what I wanted to ask Ms. Wade about in her evidence today. So, Ms. Wade, can I start? Is the CRPD relevant to your work as a legal practitioner?
It is in a roundabout way. It is not as able to be directly used by me as a legal practitioner because, of course, Australia as a state party has not truly incorporated the CRPD into our laws. So when I am running files, that is providing legal advice or representing people in courts and tribunals, I cannot mount my case on the CRPD, but it is always useful for explaining to clients, that is people with disabilities and their families, what their human rights are and what they should expect from government and institutions within Australia.
And other than the sort of direct circumstances of people bringing cases in courts and tribunals, have you had the opportunity to use the CRPD in any of your other broader advocacy work?
Yes, so I would say that my main use of the CRPD and my expertise in it is derived from my work in law reform and public policy over the last decade. So we often will use the CRPD to measure current domestic laws to identify whether or not they protect and promote the human rights of people with disabilities, and where they do not, which is often the case, then we mount law reform campaigns and seek public policy reform based on those failings.
One of the issues we want to explore in this public hearing is the relevance of the CRPD to Australian law, policies and practice. And related to that, ask the question of how do you translate rights at an international law level into an Australian setting? So I want to ask you some questions about that. But can I start by asking your experience as a legal practitioner? What do you see as an impediment to the enjoyment of human rights for people with disability in Australia?
As a legal practitioner representing people with disabilities and their families, I most crucially see that the current framing of our laws and policies as a nation, but also at an individual state and territory level, are formed in such a way that does not anticipate the inclusive participation of people with disabilities, that is my clients, or goes out of its way to preclude them from accessing their human rights. So a common example that I would see is the use of guardianship laws that are disproportionately used against people with intellectual disabilities and cognitive impairments. Now, in each state and territory, we have a guardianship and administration act of some type that principally removes the right of a person to make their own decisions and creates a substitute decision maker to make decisions for that person. Ordinarily, that substitute decision maker is a government body such as the public advocates around the country. That legislative framework that is enjoyed in all the states and territories is a harsh and unjust violation of people's human rights. And it is, yes, sorry, City Councillor.
One thing I think you've described in your writing and work is one of the impediments comes because of attitudes, and particularly an attitude you've described as ableism. And I think you've drawn some analogies to how we think about racism and the extent to which racism or sexism or other forms of discrimination might occur. Can I ask you just to explain about ableism as an impediment to the enjoyment of human rights?
Sure. So certainly, as the Senate inquiry that came before this very Royal Commission in 2015 found, that people with disabilities in Australia are seen not to be human. They're seen to be not to be rights holders. And that very sentiment we see at a very everyday community level all the time. It is this idea that people with disabilities are less than, that they are not worthy to hold their own human rights, and that if they are worthy, they can't actually do that for themselves. And so we have these ableist structures that have informed a lifetime of law reform and public policy that has created the active and long-standing exclusion of people with disabilities. What is interesting, though, is, as you say, in the context of racism and sexism, the broader community have a different perception, in my view, of the role of racism and sexism in offending the human rights of women in the case of sexism and people of different races for racism. Whereas that fundamental belief, in my view, is not held for people with disabilities by the broader community at the moment. And that makes it incredibly difficult to defend their human rights.
So if we look at the CRPD, and as I said earlier, there's a lot of jargon and legal terminology around international human rights law that includes the CRPD. One of the challenges is taking those international laws and working out how they best fit into a domestic, in this case, Australian setting. But it's got to be, doesn't it, in a way that makes a practical difference to the lives of people with disability. So by that, I mean more than just mere words or slogans, but something concrete. Do you agree with that?
Yes, wholeheartedly.
And in the work that you've done, if there is a reference to the CRPD made in laws or policies, do you see that it's starting to have the impact of making a practical difference to the lives of people with disability?
Yes. So when we refer to the CRPD in domestic law, for example, in the National Disability Insurance Scheme Act, or here in South Australia, we have a Disability Inclusion Act that also references the CRPD, we find that there is a greater anchor to reference the human rights of people with disabilities when addressing everyday issues. So if you take, for example, access and inclusion in a very general, somewhat boring sense of accessing the local cafe, that's a pretty practical problem. And we don't usually talk about the right to coffee as a human right, but when you start to insert into law that access and inclusion is a fundamental human right that is derived from the CRPD, then you have a much more effective and protective law than if you simply say, well, a person with a disability has a right to access the local cafe. So it really delivers a more practical and real sense of what the CRPD otherwise provides in somewhat motherhood statements.
So the work of the Royal Commission thus far, and one of your roles is to be AFDO's advisor in relation to the Royal Commission, and I'm aware that you've followed the work of the Royal Commission, is that there isn't a great deal of awareness of the CRPD or that sense of human rights for people with disability within the disability community, but particularly in the broader community. So we talked just before with Our Voice SA about training and awareness of rights. And this is something that you've really thought about as well. It's part of the reason, I understand, for the book that you've recently published. But as lawyers, we think about the law in a particular way. How do we translate what can be some complex concepts or rights expressed in fairly aspirational terms into something that means something? How do we educate the broader community? That's a big question to ask you, but you're up for the challenge.
Yes, no doubt. So when educating people in their everyday human rights, and this can happen as a lawyer when I'm providing advice, or it can happen when I am campaigning in a human rights issue or whatever the case. In my opinion, the fundamental thing to do is to relate the human right which you seek to explain to a practical everyday notion. So not dissimilar to as I just did with a coffee shop and the right to access and inclusion, but you need to really break down what the right means at an everyday level. And it is quite surprising the number of people, both within the disability community and the broader community, that do not know, really genuinely do not know, that it is their human right to access education, to have open and fair paid employment, to be able to access healthcare. All of these really, when you say it, somewhat obvious human rights. You really do, as a lawyer, need to explain it in those practical everyday examples. So, you know, for example, in the book, which goes through nearly every article of the CRPD by chapter, there are frequent examples of how this relates to a person's everyday life. So, you know, if you're at school and you're denied, you know, an Auslan interpreter, what does that mean in terms of your human rights? Or, you know, if you go to work and you're told that you can only work in the back room and everyone else works in the front room, or what does that mean in terms of your human rights? And I think that if you level these really big concepts in everyday examples, people can really grab hold of it and people can get it. Where it becomes more complex is in areas of what this commission is looking at around violence, abuse, neglect and exploitation of people with disabilities. So there's, you know, it's all well and good to sort of explain where, you know, your right to housing means you have a house, or your right to education means you go to school, or, you know, your right to access and inclusion is going to the local pub. But when you start talking about more difficult conversations around freedom from violence, abuse, neglect and exploitation, where we really need to think about what the examples and explainers that we're giving to people, because what we most want, I'm sure the Commission is thinking at the moment, is for people to be able to identify and prevent rather than react to those situations. And so we obviously, as a country, we have a whole body of criminal laws that will arguably respond, as we have seen in South Australia to the Anne-Marie Smith case, where sure, there are charges that can be laid, there are matters that can be dealt with in response to the violence, abuse and exploitation of people with disabilities in the community. But what we really need to be able to do, in my opinion, is properly explain those concepts that are derived from a human rights legal framework into everyday life, so that people with disabilities and their families are able to properly identify what is violence, what is abuse and neglect, what is exploitation, and then be able to actively protect themselves. And a lot of what we do in rights education is about ensuring that people with disabilities and their families can protect themselves. You know, you shouldn't have to go to a lawyer and an advocate every time something awful has happened. You know, we want people to be able to get the support that they need when they need it, sure. But, you know, the first responder is really yourself. And you need to be properly equipped with the knowledge and education that the broader Australian community do have about their own human rights. If I say to one of my non-disabled friends, did you know that you have the right to be paid fairly? They will say, absolutely, I know I have that right, and I exercise it routinely every time I get promoted. But if I say that to my fellow peers with disabilities, well, it's a little less known, because realistically, Senior Counsel, we have not had our human rights in Australia for ever, arguably, and certainly not over the last 30 years or so while they've been evolving international and domestic law.
I think it's been suggested in some of the writing is that when we come to look at human rights for people with disability, we can't turn away from the history of segregation and exclusion and setting up separate systems. Do you have a view about segregation and exclusion sitting in a rights framework?
Well, my view would be most simply put as abolishing it. I think that it really has no place in a legal and public policy framework that promotes and protects the human rights of people with disabilities. What is difficult, though, Senior Counsel, is that it's very challenging, it's almost behemoth, to properly unpick the current structures and systems in Australia that are really born on the basis of segregation. So when we look at housing, education, employment, they're some of the really big areas where people with disabilities are only able to participate on the basis of segregation and exclusion. So we see it in special schools, in group housing, and in sheltered workshops or Australian disability enterprises. And realistically, so long as we as a country are funding them and legitimising them through law and public policy, then we will not comply with our obligations as a state party under the CRPD.
One of the challenges, isn't it, in taking a human rights-based approach is when you're putting it into pre-existing systems and practices and policies, some of this can't be done overnight, can it?
No, not so far as I can tell. No, it would be great if that could be done, but I think that would almost trivialise the issue to expect it to be done in that way. What we really need, in my opinion, is for people in Australia to accept the place of people with disabilities in the community. We need to see that they are accepted as valued and rights-bearing people within our community. And then with any luck or common sense would tell me that those people holding those views would coincidentally be members of our parliament, senior officials in government departments, people that run local businesses, so on and so forth, and would in effect dismantle these structures and systems that actively exclude and for the most part commit human rights violations against people with disabilities of its own volition, really. And that's really what we need to see happen. This is not, you know, a matter simply for the disability rights movement. It's not something that's able to be achieved, you know, by community leaders or by senior advocates or even by government in isolation. It needs to be a whole of community acceptance, acknowledgement and commitment that we will protect and promote the rights of people with disabilities as a nation going forward. And we need to commit to that at an everyday systemic and structural level.
So to bring it back to some of the sort of scenarios that you're faced with and how you navigate this from a rights-based perspective, the very nature of law and seeking legal remedies might be because there is a dispute and you'll have perhaps different understandings of respective rights and obligations. Someone might assert a right. Another person on the other side might say, well, I don't actually have an obligation to afford that right to you, or it's too expensive, or there's some other reason why I might resist that right. In the area of looking at the rights of people with disability, how do you navigate these disputes? And I'm interested in asking you is, how and when do you see any limitation on rights in the framework that we presently have?
Certainly when you get into disputes, as you call them, and they absolutely are, when you have legal actions and complaints before commissions and tribunals, which at their heart seek to assert the human right of the client, it is often in large part, as you say, taken up by a dispute between you and the respondent, usually, you know, a government agency or a school or an employer or whoever, about, is that really their right? Is it their right to have the reasonable adjustments that they need to access the classroom? Is it their right to have, you know, those things that they need at work or whatever? Is it their right to have housing? And that often does take up, I would say, most of my day, senior counsel, is debating that with respondents as to what they perceive to be their legal obligation as government or private sector can, for the most part, differ quite considerably from mine as a human rights lawyer. But where that comes from is, sure, in part attitudes, right? Respondents are just people, and people have these attitudes of ableism, as I've spoken about. Part of it can come from a lack of education. Some respondents simply do not know that deaf people need also interpreters, or that people in wheelchairs need to go to the toilet throughout the day as well. So a part of it is that. But there, in my view, when you get into legal disputes, attitudes are, for the most part, a fraction of the issue at hand facing me and my clients. And in fact, what the real issue is the current framing of laws under which we practice that allow for these sort of attitudes to run rife. And so we have, sorry, Senior Counsel.
So just like thinking of examples where the CRPD has come in part into Australian law, and discrimination, which is the area that you have great expertise, is a model designed on formal equality, slightly substantive equality, but it's got this sort of balancing act, doesn't it, between the right and then there's limitations built in to it. And I want to understand from a rights-based perspective, how do you deal with those limitations?
So the limitations are dealt with by very careful legal advice and very careful presentation of the legal case. One of the real challenges that we have in the federal discrimination space for disability, so under the Disability Discrimination Act, is a lot of the jurisprudence that we've heard from the federal court and the High Court, which really seeks to close in the scope of the Disability Discrimination Act, which makes it very hard as a legal practitioner to ensure that you can squeeze yourself through the very narrow gap that is left to be able to preserve your client's rights. So what we have seen is then the Commonwealth Government amend the Disability Discrimination Act with a view of trying to open it back up, allowing for practitioners like myself to have perhaps more of a walkway than a narrow gap to squeeze through. But we have seen, as the commissioners would be aware, that that has somewhat been in vain to date, with still the Disability Discrimination Act being read by the High Court in a very narrow sense. So it's really important, I think, and I'm mindful that people watching the hearing might be at risk of getting a little bored right now of all the legal jargon that might be able to come out of my mouth in a moment. But when we have an act like the Disability Discrimination Act, which has a direct relationship with people with disabilities to enforce their right to be free from discrimination, which is a right given to them under the CRPD and other international law, I hesitate to add, then it can not only be narrowed by, or limited, as you say, Senior Counsel, by the views and arguments of the respondent, but also it is narrowed and limited by the work of the High Court and the Federal Court in delivering judgments in this space. So,
jump in there, because I think some of the models that people have talked about to give better effect for CRPD rights is to have something like a Bill of Rights, and that takes those rights into courts and tribunals. And if, as you say, some of the experience of litigating or arguing rights in courts and tribunals has been to narrow it, do you have any concerns that another model putting rights into a very legal context of having to go to a court is going to protect people's rights?
I'm of the view that at the moment where Australia is at, and all its states and territories are at, the only way forward is to provide legal protection right now. It's simply not good enough for us all to say, well, attitudes need to change, and once attitude changes, inclusion will run free through our community. That's probably true. I would like to think that the evidence I've given is true. But what is not fair in that statement is, whilst people become educated and awakened to the human rights of people with disabilities, there are people with disabilities who are currently facing significant, substantial and grave human rights violations, and we must, Senior Counsel, afford them with legal protection to ensure that they can bring forward actions against those who violate their human rights.
We've talked about education for people with disability to understand their rights. Is there not a countervailing consideration, and that is that the duty holders are educated about rights? But if you've got to set it into a legal framework, then how are we faring as the legal profession?
Sorry, I don't know that I understand the question, Senior Counsel.
So two parts to it. One is the education for people with disability about their rights.
Sure.
The second has to be that the duty holders, so those who might be respondents, those who might be in government agencies, in service providers, they have to understand rights as well.
Yes.
The bit in the middle is if you're going to have a model about enforcing those rights through a legal framework, how is the legal profession fitting into that, and how are we faring in our understanding and knowledge of human rights, particularly CRPD rights?
Okay. Sure. I think I've called the question now. Probably not. I would not describe the legal profession as being particularly progressive when it comes to disability rights. I think that for that framework that I have described, where there are legal protections in place for people with disabilities to preserve their rights under the CRPD, then we would need a legal profession that is more skilled at disability rights law, but also B, is more accessible and inclusive. So I run an inclusive and accessible legal service. I would be one of a handful in Australia that do so. And what we really need to see is for people with disabilities to be able to access their local lawyer, any lawyer, and be able to attend that lawyer in a way that is on an equal basis with others. And then sort of building on from that, we need more specialists in disability rights law so that we can properly ensure that legal representation is afforded.
Before I ask the commissioners if they've got any questions, what is the vision that you have for Australia into the future in protecting the human rights of people with disability? What would that vision look like?
My vision for Australia into the future, a future that is somewhat lengthy, I suspect, is that we have a society that promotes and celebrates disability, that we no longer advise pregnant women that they should have abortions when they receive the news that their child may have a disability, that we don't remove children out of disabled families, one where people with disabilities go to work with everyone else and are paid fairly, where children are educated on an equal basis with others. I would really like to see, and I perhaps am making it my life's work to ensure that people with disabilities are treated equally with others. But that's also to say senior counsel so fundamentally that they live a life free from violence, abuse, neglect and exploitation. We know through this commission that my community, the disability community, face disproportionate rates, almost double that of people without disabilities experiencing violence, abuse, neglect and exploitation. And the vision that I have for Australia is that ends. That has to stop. That future cannot be delivered in some decades, and it has to arrive imminently. I also really would look forward to having people with disabilities be active leaders of this country, to take an active role. We talk a lot about having the seat at the table. I would like to see people with disabilities really take up a lot of the table in conversations about them. I think realistically, the vision would ensure that people with disabilities are creating the conversations about them, not that they're being involved in conversations about them. It's really one of equality and rights protection.
Commissioners.
Yes. Do you have any questions?
Yes. Thank you, Chair. Ms. Wade, thank you for your evidence. Just a few questions from me. Firstly, you mentioned earlier at the beginning of your evidence the dehumanisation of disabled people. How significant is that as a barrier to achieving what we want through the convention?
Commissioner, I would say that it is a significant, if not the largest barrier that we face. We know as human rights lawyers that if you do not see a person as a human, you will in turn not see them as a rights holder. And that is a fundamental issue that is faced in Australia right now.
Okay, thank you. And my second and last question, which is sort of related to the first one, is you said that most of your work is about debating or arguing for the actual fundamental right of the disabled person. So do you think that is also another significant barrier?
Is it, sorry, do you mean, is it a barrier that we have to fight for those rights?
Yeah, the very fact, the fundamental facts.
Yes, absolutely. I would say that when presenting particularly cases of disability discrimination, but also when presenting cases in the social security jurisdiction before the AAT or guardianship matters at a state level, the primary starting point, Commissioner, is that your client should not have access to those rights. The right to social security, the right to be free from discrimination, the right to have their own decisions, or their decision-making capacity be awarded to them. So as a disability rights lawyer, you are constantly coming from a you have lost the case until you have won it, because the recognition of those human rights are so violated by those frameworks. The very essence of guardianship law is to remove the decision-making capacity. And so you are, even though at a human rights level, the presumption is that you have capacity to make your own decisions until proven otherwise. And that would still be true in the objects of the State Guardianship and Administration Act. But what we see in practice is service providers and other large institutions, much more powerful than our clients, present applications to tribunals in all sorts of jurisdictions that start from the position of, well, they are disabled. Of course they cannot insert right here. And that creates a really complex environment for us in terms of presenting the case, but also in terms of the advice that we provide clients. So we certainly don't start the advice with how wonderful you have your human rights enshrined in the Disability Discrimination Act. We're just going to march down to the Australian Human Rights Commission and ensure that your rights are preserved today. Usually that advice is more, we have lost until we have won. And you need to go into that with your eyes wide open. So it is very difficult for complainants and clients when faced with legal frameworks that, Commissioner, often they had no idea existed. Like, often people with disabilities and their families don't know, understandably, about the inner workings of social security law. They just thought that when they turned 16 and they had a lifelong disability, they would be able to access the disability support pension. But really, the way in which that law operates through the Social Security Act, and particularly through its impairment tables, works on this prohibitive basis of violating a person's human rights to refuse them access to social security.
Thank you, Ms. Wade. Thank you, Chair.
Thank you, Commissioner McEwen. Commissioner Ryan, do you have any questions?
Not that could be answered quickly. I found this interesting, but no, I won't ask questions today.
Very good. Okay, thank you. I'll now ask whether there are any counsel who wish to ask Ms. Wade any questions. That is, from parties given leave to appear. If not, thank you very much, Ms. Wade, for coming to the Royal Commission and giving evidence, and for granting permission for your book, which we have in our documents to be available to anybody who wishes to look at it. And there is some very valuable material in there, and I do encourage people to have a look at it. It is, as Ms. Eastman said, very generous of you to make the contents of that book available in the manner you have. So thank you very much.
Thank you, Chair.
Thank you, Commissioners. Could I tender then Ms Wade's CV and ask you to mark that Exhibit 18.6?
Yes.
And also to tender an illustrated handbook on disability rights that was authored by Ms Wade as part of Equality Lawyers. And could you receive that into evidence and mark it Exhibit 18.7?
Yes, thank you. Ms Wade's curriculum vitae will be Exhibit 18.6 and Ms Wade's book will become Exhibit 18.7. Thank you again.
And I thank Ms Wade and particularly the excellent publication, which I'm sorry I haven't had the time to walk you through in detail, but thank you, Ms Wade.
Thank you, Sydney Council.
Thank you. Do we now adjourn?
We now adjourn for 1 hour, Commissioners, for lunch.
Yes, all right. We'll adjourn now and resume at 2 p.m. Australian, Eastern Summer Time.
The Royal Commission is adjourned. Royal Commission is resumed.
Yes, Ms Eastman.
Thank you, Commissioners. Our next panel will be a panel of 4 advocates with a deep understanding and experience working with human rights, particularly the CRPD. So I just might go around this way and first introduce from our Brisbane hearing room, Kelly Cox and Francis Kwan Ferrant. So you can see them in our Brisbane hearing room.
We can.
I'll just make sure that they can hear us.
Yep. Yes, we can hear you.
And then from other locations, we have Damien Griffiths. Can you hear us?
Yes, hello.
Thank you. And June Reimer. Right, so
now you'll have to unmute yourself, Ms Reimer, I think.
all right, so
is there someone with Ms Reimer who can assist if necessary? At the
we
moment,
may have to come back to Ms Reimer. So Commissioners, with a panel of 4 and all from remote locations, I'll take my time to make sure that we can cover everything that we need to cover, but I may need to do a bit of protective interruption at times. And I'm just conscious that Ms Reimer still may not be able to connect with us,
yes.
But we might start if that's...
Yes, I think perhaps if we start, and we'll do that by thanking Ms Cox, Ms Farrant, Mr Griffiths and Ms Reimer for participating in the Royal Commission's hearing and coming to the hearing in order to give evidence. We're very grateful to you. I'll now ask Ms Eastman to ask you some questions. Ms Reimer, if can you hear us?
Yeah, sorry, I lost my screen for a moment. Sorry. Thank you.
That's fine. Thank you. We can hear you now. And Ms Eastman will now ask some questions. Just so you're aware, I assume you can see us all, but I'm joined in the Sydney hearing room with Commissioner McEwen and Commissioner Ryan. So all 3 commissioners involved in this hearing are in the one room.
Might start with in our Brisbane hearing room, and if it's convenient to everyone, I'll just use first names. So Kelly and Francis from PWDA Australia. Can I ask you each to briefly introduce yourself and tell the commissioners what your role is at PWDA? The commissioners have your CVs, but I'm keen for them to hear what your role is, particularly in terms of working with the CRPD.
Yep, I'll have it set. So I'm the Vice President on the Board of Directors. So my role in terms of the organisation is the more overarching, strategic planning and goals and stuff like that, the staff then do a fabulous job, implementing.
And Frances?
Thank you. I'm the Senior Research and Policy Officer with PWDA, and my role covers all of our work around the DRC, as well as our research work, and most anything to do with violence and violence prevention, as well as the NDIS and some international work.
Now I'll turn to First Peoples Disability Network, to Damien and June. We now have you. So thank you for returning to the Royal Commission. You've both given evidence at previous hearings, including at Public Hearing 5, and the commissioners have the opportunity to reread your evidence and your CVs from that hearing. But could I ask you to introduce yourselves?
Thank you. My name is Damien Griffiths. I'm the CEO of the First Peoples Disability Network. So we're a national organisation representing First Nations people with disability and their families. Had a lot to do with the UN Convention on the Rights of Persons with Disability, and most recently co-led the Australian Civil Society delegation to the UN Committee on the Rights of Persons with Disability in September 2019.
Thank you, Damien. June?
Hi, thank you very much. Thank you, Commissioner. So my name's June Remia, Deputy CEO of First Peoples Disability Network. So my main work is organisational structure and project delivery with the DRC and the Closing the Gap working groups.
Commissioners, you heard this morning that when Australia signs up and ratifies the CRPD, that it may have to appear before the CRPD committee on occasions to give an account for how Australia is implementing the CRPD rights in Australia. And that process involves the committee reviewing a report from the Australian government and then participating in what is sometimes called constructive dialogue. What I didn't mention this morning is that there's a very important piece of work in how Australia engages with the CRPD committee. And that is that the committee members have the benefit of something called a shadow report. The shadow report is prepared by organisations such as FPDN and PWDA and a range of disability advocacy groups, the DROs, the DPOs. And so one aspect of looking at advocacy in the context of the CRPD is to understand how Australia engages at an international level, but also how Australia then brings those report cards back to Australia and takes those report cards to address laws, practices and policies. So I wanted to start by asking this panel a little bit about their experience at the international level, and then come to look at the work that they do in the Australian context. So can I, Damien, perhaps start with you, because you were the leader of the delegation that presented, in effect, the shadow report. What can you tell the Royal Commission about how CRPD advocates work at that international level?
Well, there's several steps to the process. The first part is, as you mentioned, the shadow reporting. So that involved significant coordination by a number of disability advocates, disabled people's organisations and disability representative organisations, and that occurred 2 years in advance of the appearance to the committee in Geneva. And that group met regularly to identify priority issues that DRO and DPO organisations wanted to take to Geneva. So organisations like People with Disability Australia, the First Peoples Disability Network, Australian Federation for Disability Organisations, Women with Disability Australia, to name a few, were key partners in that. And there were also several community legal organisations that played a role in that as well. And that group met regularly over an extended period and formulated the shadow report. The work of Carolyn Framada was the CEO of Women with Disability Australia, who the Commission would know was integral to that. She was largely responsible for a lot of the text in the shadow report. And then we, prior to going to Geneva, we sort of identified priority issues and who were the committee members who had a particular interest in certain aspects of disability rights. And we then beforehand try to seek meetings with them. And then when we're in Geneva, we go ahead and do that. So it's quite a involved process. It takes quite a lot of time. It's not resourced work, I would have to say, and it does take quite a commitment on part of all the organisations.
And Kelly, you were part of the delegation that went to Geneva. What can you tell the Royal Commission about how the committee quizzes Australia in how Australia's complied with the CRPD? What were your observations?
I think, and I wasn't on the board of PWDA at that time, so I went as part of the civil society delegation. The committee were very, very interested in the way that things happened in Australia, for disabled people on the ground. And I think one of the recurring things that kept coming up, during meetings through the week was that the issues that they were hearing were the same things that they'd heard in the last review. That, the 2013 concluding observations have the same things that are, in the 2019 one. And that, I think, that stood out to all of them.
And the Australian government has provided for part of this hearing a copy of its report to the committee. But in addition to the Australian report, there's something called concluding observations. What are the concluding observations, and what are they intended to tell us?
Yep.
Who would like to answer that one?
Well, I could start, and then Francis might want to go in. So the concluding observations. So the week at the UN, so that we arrived as the civil society delegation with Damien leading, and we have meetings, individually with the committee members, and sometimes, as a whole, more formal structured thing. And that leads to the end of the week, where the Australian government then also have a session, and Ben Gauntlet, the Disability Discrimination Commissioner, was there. So at the end of the week, the committee meets with government and then gets to ask government, their questions based on, the reports they've received, the meetings they've had with us. And then from that, the concluding observations are released via document, which are the recommendations basically of what the committee's heard and read, and what they think Australia needs to do to make sure that we're, meeting our obligations under CRPD. Yep. I don't know if anyone's got anything else to add
to that.
No, that's absolutely correct. Yep.
Well, Damien and June, can I ask you, with the set of concluding observations, does that inform the approach that you take to do the advocacy work that you do in Australia? Do you bring those concluding observations back to Australia?
Yeah, I'm happy to go first, Junie, and then you might want to jump in. But no, absolutely. And as Kelly said, the UN committee was very disappointed. In fact, you could argue quite scathing in terms of the lack of progress on a couple of issues in particular. One of them was the indefinite detention of First Nations people with disability in Australian prisons, where there'd been no progress. There was also significant commentary on the lack of progress in terms of the issue of sterilisation of women and girls, which I know the Commission has investigated in previous hearings. And there was also particular concern from the European committee members about the way that disability represented organisations are structured, and perhaps the lack of, be fair to say, financial support for representative organisations, which is a different structure to the European structure. And it would be fair to say that the committee, and we would support this view, believes that Australia should be held to the highest possible standards in terms of human rights, because we are such a wealthy country, and we were very encouraged to see that view, because we would support that completely. But yes, it absolutely informs our advocacy here at home, no question.
So I want to ask you both, organisations about how the CRPD has influenced and shaped the work that you do in Australia. And June and Damien, can I start with you? Because when we read the CRPD, there's no specific mention of the rights of First Nations people or Indigenous peoples with disability in the convention. And we've heard a lot about the cross-cutting rights, that there's a provision dealing with women and disability, for example. So can I start by, how does the CRPD fit with the protection of human rights of First Nations people?
Did you want me to go first again, Junie, and then you jump in?
Yeah, you're right.
So one of the shortcomings of the UN Convention on the Rights of Persons with Disability, as you just said, was, yes, there is no specific article on the rights of Indigenous people with disability. Now, we would say that's very problematic. So Indigenous people with disability are mentioned in the preamble, and you can draw an association to some of the articles, like the articles on culture, but we would say that definition of culture is very much a Western sort of definition, as in being able to access cinemas and playhouses and all those obviously important things, but not necessarily about Indigenous culture. So the reason why that happens was, it's pretty simple, really. When the UN Convention was written up, there was no Indigenous voices there during the process of the actual writing up of the convention. So we worry that that's still a shortcoming of the convention. Having said that, though, that's increasingly recognised, no doubt, by the UN committee, and that's certainly something that's good. The only other thing I would say is, the other thing that concerns us is we can't necessarily rely on other human rights instruments either. So the Declaration on the Rights of Indigenous People doesn't have the status of the convention, obviously, and is pretty silent on disability. The Convention on the Rights of the Child is perhaps the best one we can use in terms of rights of Indigenous children with disability. And the only other convention where we've actually been quite active around is the UN Convention Against Torture and Inhumane Treatment, where we often frame indefinite detention. But yeah, that is a shortcoming of the CRPD convention still.
And one of the concepts in the CRPD is this idea of intersectionality, so combinations of rights. And that expression, intersectionality, is not something that really reflects a First Nations experience. What's better language that we should be using or thinking about to understand intersectionality with respect to First Nations people with disability?
Yeah, Jeannie will want to make a comment here, I'm sure. The language is clumsy and very technical. We would tend to talk about whole of life. Jeannie could talk to what makes you strong. They're better terms than dividing rights up into disability and Indigenous. Our people with disability have multiple identities. They're people with disability and Indigenous people. And of course, there's other identities too. So yeah, it's a technical term and an important one, but one that we wouldn't necessarily use in community itself, Jeannie?
Yeah, so correct. So we would say, you know, every person has a right to live on country and be included in culture, and particularly those with disability. We know that they're a resilient race. And so regards to the CRPD, unless you include culture and country as a crossover and intersectionality around, you know, how a person lives their life, you're not supporting them to live their best life. So there's many gaps that we would see, you know, in regards to our First Nations people.
I might come back in a moment to sort of ask you about how on the ground you approach these different sets of rights and bring them together. Before I do that, can I come back to Kelly and Francis? In terms of PWDA, I think you've been an organisation very active in Australia for over 40 years now. How is the CRPD relevant to the work that you do?
I might just say quickly, it's a benchmark. It's the one of few things that you can hold up and go, this is how it should be, you know, compared to how it actually is. But I'll let Francis go into more detail on that.
Sure. Yeah, no, No, you're absolutely correct. A benchmark, but it's also just the beginning. You know, it's not the ultimate incarnation of rights for disabled people in Australia. It's the beginning. So in terms of our work at PWDA, we do both systemic work and we do individual advocacy. So you would be aware that PWDA was involved at the very beginning of the development of the convention, where we went out and we did the field research. So you'd be aware of that. And so we've used the CRPD in our systemic work, and we refer to it constantly in our systemic work in all of the reports and the submissions that we make. We also use the concluding observations, in particular around Article 12. Then in our individual advocacy, this is where it gets very, very difficult, because the application of the CRPD in individual advocacy is actually more of an education exercise, because the CRPD has not been fully implemented in domestic law across jurisdictions. So we have advocates across Australia who are navigating various pieces of legislation. And whilst the CRPD, yes, it's our benchmark, yes, it's what we want to see, we're working with legislation that doesn't recognise it, let alone recognise disability rights. So we're faced with barriers all the way, barriers for the people that we're working with in order to operationalise human rights for people with disability.
When you're talking about operationalising human rights for people with disability, what exactly do you mean by that?
Good question, Kate. So that means that people with disability are recognised as full citizens in this country and have access to every system and structure, just like everybody else in this country. That's what operationalising human rights is. The CRPD, as you know, has a specific agenda for social change. It's transformative equality. That's what it's about. That's what the operationalising is about. And we are faced with barriers because we've got these interpretive declarations which no one has any appetite to remove. If we don't have it in the law, we can't operationalise it. We're just faced with a brick wall. And the people who are most affected are the people that we're working with.
Before I ask you some questions about that, it's the case, isn't it, for PWDA, is you also look to some of the other international conventions, and some of your recent work has focused on what's called OPCAT, being the optional protocol to the Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment or Punishment. So it's a bit of a mouthful, but we've put OPCAT in our glossary of terms. Now, this is going to be some new international legal standards. How is the OPCAT relevant to the work that you're doing, and what have you been doing?
Oh, it's completely relevant. We've got people who are, who have been deprived of their liberty, oftentimes for their bulk of their adult lives. We've people in detention, disabled people in detention who are deprived of their liberty. We have people who undergo inhumane forced treatments, particularly here in Queensland, multiple times. So no, the OPCAT is absolutely essential in the way that we argue systemically for change and for the rights of people with disability.
So I want to open it up now, because one of the real challenges in taking international laws, and particularly human rights that might be expressed in aspirational terms, how do you take those rights and make them concrete and, as you say, you operationalise them in Australia? What's the way in which you approach that task? Perhaps ask June and Damien.
I'll go there, June speaking. I think, we need to share the information and share about these rights across communities and embed that expertise with our service system and our communities, that, you have a right as a First Nations person to be included in society at all levels.
Damien, how aware are First Nations people of their rights in the way June has described?
Yeah, I think this is one of the big challenges we face. So as Junie outlined, we see it as a priority educating and informing our community members about CRPD because there's a very serious lack of awareness. In fact, I could probably count on both hands a number of First Nations people in Australia that actually understand the mechanisms of the CRPD and the articles within it. And we need to educate and inform our community so they can start effectively self-advocating. So to that end, the Victorian government's recognised that need, and they fund us to deliver what's called the Lester Bostock Human Rights Training Program. So that's named after our founding elder, Uncle Lester Bostock. And what that is about running workshops across Victoria with community members so that they understand disability rights. It's a very serious weakness. But as Junie touched on too, we also need to educate and inform our wider First Nations justice sector. Don't really understand some of these rights. It's not a malicious thing, but we still see some of our community members being discriminated against by, perhaps land councils or whatever it might be. Again, not done maliciously, but simply because there's a lack of awareness, say that, you need to provide an Auslan interpreter as a land council meeting, for example. So we really need to invest across the country, and we've had requests for that training in language, in traditional language. The idea being there that it's not possible for FPDN to be in every corner of the country, but the next best thing we can do is get mob to understand themselves what their rights are. So when they enrol their young child with disability at school, they can say, "Hey, no, my child's disability needs to be accommodated here," or "I've got a right to go to the chemist there, and you've got to get rid of that front step," or whatever it might be. So all those things. And Junie, I'm sure, would love to, if we get a moment, to touch on how we deliver that training, because it's done very culturally accessibly, and we often do it through art. So, yeah, we really...
Let's while we're on the topic, because I don't want to forget it and then not come back. So, June, do you want to talk about how that education of rights through art and language and culture, how does that work?
Yeah, so the training program we've developed is to break down through traditional artwork the CRPD articles. So, for example, the right to justice, the right to education, the right to be included, or accessibility. And we've developed cards that allow people, and we've broken it down into simple English for our community, what those articles mean. But we've painted it also in traditional artwork, so people understand, they connect with the artwork as a First Nations person, but then have the cards to inform them of appropriate articles. So when they're accessing community, whether, as Damien said, housing, education, the disability support pension, they can use those articles in their words to say, I have a right to access this program. So an example, I'll just hold up one of the cards for you, is access right to justice. I don't know if you can see that. So, and it's done in traditional artwork and what it means on that Article 35. So we've developed all the articles around appropriate artwork, and we do these in a 2 or 3 hour workshop with community. We also have developed human rights advocacy resources. So what does advocacy mean in your life in regards to the CRPD?
And coming back to Kelly and Francis, are you aware of whether the Australian government has published an easy read version of the CRPD?
Not that I'm aware of.
Not recently that I'm aware of that it's particularly accessible. There are a range of links on the government website, particularly in relation to the concluding observations, though they're not all complete. For example, they don't have a copy of the most recent concluding observations up on their website. No, not accessible. No.
Do they have the concluding observations in easy read, for example?
No, well, they don't have the concluding observations up the last time I checked, which was on Friday last week.
So in terms of how people with disability are aware of their rights, Easy Read is one way of assisting people with intellectual disability to perhaps understand their right in an accessible form. What's your knowledge or awareness of other ways in which rights can be communicated to people with disability?
Could I just say that having it in Easy Read is one thing and it's great, but people need to know that their rights exist to know to go and even look for something in Easy Read.
Yes.
For most cases, people don't know they have rights, much less where to navigate on the internet to find it in an accessible format.
Absolutely, Kelly. So one of the things that we do is we run workshops around the NDIS. We run various other programs around violence prevention, and we include the CRPD and explaining that in all of those programs that we run. And one of the things that comes back to us on a regular basis is people are shocked they even have rights. They had no idea. So yeah, part of the work that we do is simply going out and educating people, not just people with disability, I might add, service providers as well, and government agencies. They're not necessarily across it, I can say, with confidence.
That's a very helpful sort of step into the next area that I wanted to ask you all about, and that is, it's one thing for people with disability to understand their rights, but there's also those who have duties and whose activities may impact on the lives of people with disability and their rights. What has been your experience in the level of knowledge about the CRPD or the human rights of people with disability on the other side, which is the duty holders? That might be government, might be corporations, might be service providers, but you know what, it might even be family members and supporters. I think, Damien, you've touched on this a little bit in terms of the justice system and community. So, Kelly and Francis, can I start with you? What's that level of awareness on the other side, the duty holders?
Very, very limited.
Extremely limited, particularly when it comes to family members. And I can say that in our experience, in the work that we've done in the field, both through individual advocacy and our project work, not all family members are particularly happy about the concept of people with disability having rights. I know that's not comfortable, but gatekeeping is a real thing. We often think of gatekeeping as being a service provider thing, and certainly it is. It's also extends to beyond that. In terms of service providers, I think widely, in the last couple of years, perhaps the language of the CRPD has been applied in various aspects around policies and procedures, but I would say that it is simply using our language and that it is more of a tokenistic thing. I do not believe that there is any full understanding of what human rights for people with disability is really about, apart from ticking a compliance box.
Yeah.
When it comes to government and the layers of government, this is again problematic because the two mechanisms for the application or implementation rather of the CRPD is the National Disability Strategy and of that the NDIS. Now, the National Disability Strategy, even when we had the previous iteration, was not well understood nor well known outside of DSS, federal DSS. And we certainly had perhaps heated exchanges with certain state government departments who objected when we put references to the CRPD in reports we were preparing for them because they didn't think it was relevant to a state. And so part of our job was to explain to them, well, actually, it's, the National Disability Strategy to which, you're signed up to as part of the implementation of the CRPD, that influences all your disability policy, including this piece of work. So, that's very disappointing. And we also forget it's not just the state and territories, but the National Disability Strategy covered local government. And we're not talking about that enough at all.
Damien and June, in the context of your experience you've got First Nations people's rights and disability rights. When you come to have the conversations with the duty bearers, how do you navigate the First Nations and the disability rights? Is it possible to speak to them together, or are they different conversations because there might be different audiences?
Yeah, I might jump in there, Jenny. I think intersectional discrimination, using that term for the purposes of the hearing today, still confounds the system, be it Commonwealth government, state governments, local government, the local shopkeeper for that matter. And we're still in a situation where we would say most of our community members with disability walk in three worlds: the disability rights world, the First Nations rights world, and then the everyone else world. Some examples how that plays out practically, which again demonstrates how systems don't know how to address intersectional discrimination. It's not unusual for us to get a call from a parent, say, when they're enrolling a young Aboriginal person with disability at school, and they'll often ask us the question, should I tick the disability box or the Aboriginal box when I enrol my child at school? And what they're saying there sometimes is, well, what will get me the best potential resources or support for my child? So the thing that's, of course, silly about that is they have both identities. I think the other thing I'd say, I would say there is very little understanding of the CRPD, talking in generalisations, by duty holders across the country. We don't even really in Australia, haven't really even had a conversation about things like ableism, for example. So we could talk about racism. Well, we can't talk about racism today, I'd argue, in some ways because it's such a sensitive issue. But racism is a term that Australians are familiar with. Ableism is not a term that people have ever really engaged with. And I think that's something that shows that we have such a long way to go in terms of raising the profile of disability rights in general in Australian society. I don't think it's a common concept. I don't think there's enough knowledge of obligations on the part of duty holders, and I would relate that to the fellow who runs a pub on George Street in Sydney, to the BHP. It's not part of the Australian vernacular, and I think we need to change that still. I think we have a very long way to go yet.
I mentioned this morning that the Royal Commission, in the preparation of its interim report, and also what the Royal Commission has heard to date, is this critical role that advocacy groups play in often translating rights to people with disability and the duty holders, but is sometimes the bridge between these two worlds. The CRPD has a special role for DPOs, DROs. What's been your experience in terms of being that bridge, and how do you discharge that function? I don't mind who goes first on this. Kelly or Jack?
Damo to go first.
Yeah, Damo can go.
To be honest, Kate, I think this is, again, it's one of the criticisms that the committee makes of the Australian system, if you like, in that the committee has often reflected that the resourcing of disabled people's organisations and disability representative organisations is not satisfactory in terms of being able to meet need. So obviously the ways we try and do that is through individual advocacy, systemic advocacy, but the demands, certainly from a First Nations perspective, are so great that it's impossible to meet individual advocacy needs. And we need to, I think there's a problem with the language too, I would argue. There's still such a sensitivity on part of some governments of the term advocacy. It's often viewed as perhaps adversarial, and I think we need to change the way government systems think about it. It's not necessarily about adversarial outcomes, it's about support providing to a person with disability so they can participate in community life. That's a long title for a job, but that's really what our people, advocates do. They provide support to community members so they can have their titles, their rights met. And I think we need to, governments still have well, here comes an advocate, look out, this is going to be another fight sort of thinking, when really what we need to be thinking is this, no, this is what a person's support required to be able to participate in community life. And then I think that we might get a little bit less of the adversarial sort of stuff that can sometimes be the perception of government, I think.
Yeah. Kelly and Francis, can I just mention this? When we spoke to AFDO last week, someone in the group told us this. She said, I liken us to being a rubber band on its full stretch. We are so busy in survival mode that when our lives fall apart, if a carer doesn't turn up at the day and the time that they're supposed to, then that's a life-altering day. So people don't realise that they have a right to ask for supports and to expect those supports will be delivered at the pre-arranged time. And they told us that often it's not until a person is at a crisis or an acute situation that they may find their way to an advocacy organisation like yours. And at that point, they become aware of their rights, but essentially they're in crisis mode.
That's right.
How, as an advocacy organisation, do you approach that under this broader umbrella of CRPD rights and protecting rights?
I'll let you take that.
Okay, well, speaking from an individual advocacy point of view, we have intake, obviously, and you're absolutely correct. Most of the people who come to us are in crisis. A good 20% of the people who come to us have experienced some form of violence. One of the biggest issues we face, and this is across all our advocacy work in Australia, in Queensland and New South Wales, is homelessness. Homelessness. People are on the brink, and it's regardless of whether they're in NDIS or not. And the CRPD doesn't necessarily articulate completely the right to housing, but the right to housing is a human right. And the right to, live your life as a citizen is certainly in the CRPD. So it's extraordinarily difficult. As I said earlier, we're faced with all these barriers because the human rights of people with disability are not articulated in domestic law anywhere in Australia outside of the 1992 Disability Discrimination Act, which is, less than adequate, particularly now. So yes, crisis is something that we face. And how do we resolve that with the CRPD? Well, we try, and education is part of that. But as Damien pointed out, we are like a stretched rubber band. We don't have enough resources to deal with the demand that we are facing. And I assure you, we are facing pretty heavy demand.
So coming to this question of accountability, if we're going to have a rights-based framework, there has to be accountability for the duty bearers. Mm-hmm. What is your view about how accountability for meeting the CRPD obligations operates in Australia? Kelly and Francis, can I start with you?
It doesn't. I can elaborate.
I think, and one of the things, and I think it's come up, earlier today and certainly in our discussions ahead of this, is that CRPD isn't reflected in common law. So, we need to put that disability or CRPD lens over, existing laws and seeing whether, that they're in line with it and they meet it, and can people's rights be realised under existing laws. And I'll let Francis elaborate.
So that's something that's a continuing theme, obviously. The fact that the CRPD isn't reflected in domestic laws, that we have interpretive declarations on Articles 12, 17 and 18, which create barriers, but also in terms of an adequate mechanism, and this was brought up in the concluding observations of 2013 and in 2019 again, that there is not an adequate oversight mechanism. And in the 2019 concluding observations, the committee pointed to the Australian Human Rights Commission as being that place where that could take place. There has been no progress on that. There is inadequate monitoring and evaluation across disability policy from a federal level and state level and territory level, regardless. The National Disability Strategy, the new one, once we get it, is housed within DSS. It's siloed away. It's supposed to be a broad policy, and it is one of the mechanisms, or the chief mechanism, for implementation of the CRPD, and should include in it monitoring and evaluation and accountability. I don't know what the new National Disability Strategy is. I have not had privilege to see it. And, you know, we don't know what's going to happen there. But there isn't a mechanism that is satisfactory, and there does not seem to be any appetite to develop a mechanism that is satisfactory.
Was there any form of mechanism in the National Disability Strategy that operated between 2010 and 2020?
No. This again was brought up in the concluding observations of 2013 and then reiterated again in 2019. It was inadequate. The committee found it inadequate wholly.
Damien and June, coming to that question of accountability, I think, Damien, you've said that maybe First Nations people walk in three different worlds. In the three different worlds, is accountability equal between those three different worlds?
No, in a word. One of the things that we've put forward to DSS and government more generally over the years is a more formal mechanism that can operate under the Australian Disability Strategy, or the National Disability Strategy as it's known, that can draw upon the structure of closing the gap. So we've suggested for a long while now, why isn't there a similar structure for disability? So perhaps on the 3rd of December every year, the Australian Prime Minister of the day has to address the Australian Parliament about a whole lot of measures as they relate to Australians with disability, including our people with disability. We think that is an idea that has a lot of merit, and would think that that would be a fairly immediate action that could happen. Closing the gap has its failings, of course, and from a disability perspective, we'd be the first to say that. Mind you, over the last couple of years, there has been change now. So there is recognition of disability under closing the gap. So eventually that system is moving, but why can't we have a similar mechanism that focuses on disability? And also, I would have thought there are a number of very measurable things in disability that state governments could provide, the education experience of Australian kids with disability, for example, or how many accessible train stations we have, or whatever it might be. And we've long advocated for that and wonder why there isn't some sort of structure that is similar to the closing the gap one, but is focused on Australians with disability.
So I might turn to the commissioners now, because my final question for all of you is, what do you think needs to be done now in Australia to better implement the CRPD? Or you may speak to that in terms of a vision looking forward. So can I leave that question with you, but just ask the commissioners if they've got any questions before the final question.
Yes, thank you. I'll ask first Commissioner Ryan. Do you have any questions?
Look, I was just wondering, with commendable as it might be to have the CRPD codified in some way and lawyers the opportunity to go and operate in the courts, is it not so that the biggest barrier to implementing the rights of people with disabilities comes from our parliaments and the allocation of budget measures? And would not a system that, in fact, Mr. Griffiths has just suggested be, in fact, an even more important way of achieving the implementation of the CRPD?
Yeah, I'm happy. I would argue, Commissioner, we need both. We need a strong and robust CRPD application in domestic law that could inform parliaments, actually. But we also need a culture within the Australian parliamentary system and the state and territory parliamentary system that actively, seeks members with disability. So I think it's I think it's reflective of the long way we have to go yet to realising the rights and the protections of Australians with disability in general. So I'd argue both. Yeah, definitely. Parliaments should hopefully be reflective of Australian society and the way they're made up. And I don't think we do well in any parliament in Australia on that. But also we need to understand that there, as a society, there are some basic human rights that people with disability have, and it's everyone's obligation to make those rights, I think.
Yeah.
Thanks,
I
Mr.
agree.
Chair.
Yeah.
I think we need people to care about our rights as disabled people, and when they don't care, we need a way to enforce it, I think is at the end of the day.
Yeah, it has to be in domestic law, and there needs to be a monitoring and evaluation mechanism that is clear and outcomes are ticked. It has to be both ways.
And I think, like in regards to the NDIS, we don't need to see, First Nations or any person with disability as a burden to society. So it's changing language, changing imaging. And that's what we don't hear from the government, It's time for change. We want actions for people with disability to be first and foremost in any policies.
Commissioner McEwen.
Thank you, Chair. Thank you to each of you for your evidence, and thank you also for the advocacy work that you and your colleagues do for disabled people. We've heard in this Royal Commission the issue of disabled people not getting access to advocacy services. We've heard things like gatekeeping, for example, Francis mentioned gatekeeping, and also kept out of reach. They might be isolated in group homes, etc. What do you think the Royal Commission should be looking at carefully to ensure that we can address the issue of people getting basic access to advocacy?
So the funding of the NDAP program needs to be further monitored and supported. There's currently not enough advocates nationally. So that was one of the recommendations, with the National Disability Advocacy Program. There isn't enough First Nations advocacy groups, and we need more work around supporting self-advocacy for people with disability.
Yeah, I absolutely echo those points, Commissioner, from Aunty June. I would add on to that, we also need to recognise that our advocates must have capacity to get out into regional remote Australia. Yeah. I think that still remains an untold story in many ways. The COVID situation has exposed this only further. The situation for many First Nations people with disability in regional remote Australia, to be blunt, is one of abject poverty. And the only way to get meaningful support to our community members out there is to go see them on country and try and seek support. So the National Disability Advocacy Program is inadequate in funding. Perhaps we might need to change the name and make it more about supports for people with disabilities, so there's less sensitivity on the part of governments. But this is about creating opportunities so people can participate in community life as is their right. I think we still lack a focus, like Junie said. We don't have a focus on First Nations people with disability, and we're tired of arguing for that, frankly. There needs to be a specific First Nations disability advocacy program. And if I can be blunt, I don't care where it comes from, but it's long overdue. And we need it to be implemented a decade ago. With that case has been well and truly made, but it needs to have within it a recognition that it has to be about engaging all of our communities across regional remote Australia as well. And then the other thing is investing in education. So the other element is investing in, the human rights training programs that FPDN and others offer, so that can effectively create a self-advocacy movement, so people can start speaking up for themselves, which is their right too, of course. So I think there's clear ways forward. It's just a matter of government needs to reach into their pocket like they should have done a decade ago, I suppose. But yeah.
Yep.
Thanks.
I think, and just to, in the absence of fully funded advocacy support, and your reference to people in group homes and, people in day programs and all of that. I think it's important for the commissioners to know that as part of the NDIS rules or policies, if you're a support coordinator or a service provider, you're not allowed to advocate for the people you support. It's a rule, particularly, for support coordinators who are providing support. Like Damien's definition of advocacy is correct. It's providing people support to meet a particular outcome, which I would argue is also the role of a support coordinator. So they can't advocate. It's a very confusing line and results in bad support sometimes because they're trying not to break rules and affects the outcome. And I think, again, Damien's view of, or the government's view of what advocacy is, he's right. It shouldn't be seen as a bad thing. It's a positive thing if somebody's got help to communicate what they need.
Yeah, and just to elaborate on advocacy and the right to representation, I mentioned earlier that our advocates are working at full caseloads, and we also do NDIS appeals, and we have a backlog of NDIS appeals, and I'm sure you're aware of that with the AAT. That is also it's a David and Goliath battle for a person with disability to go to the AAT. Why is a disabled person not allowed to have a lawyer? Why does the NDIA have lawyers, and yet a person with disability does not have a lawyer? It's unfair. The power imbalance is outrageous. And why would you deny a person with disability the right to equality before the law, which is, of course, Article 12? So we need to get rid of those interpretive declarations, just as a final note.
Thank you very much, all of you. Thank you, Chair.
Thank you. One of the themes we've heard today is related to the importance of translating principles of the Convention into domestic law. I'm interested, particularly from Ms. Cox and Ms. Farrett, how would you do that? Yeah. Take Article 12, for example, that you've referred to. Let me just remind people what Article 12 says, because not everybody will know the Convention off by heart. That reaffirms, state parties reaffirm, that persons with disabilities have the right to recognition everywhere as persons before the law. Subparagraph 2, states parties shall recognise that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. And I'll just limit it to subparagraph 3. States parties shall take appropriate measures to provide access to persons with disabilities to the support they may require in exercising legal capacity. I'm interested in how you suggest that those principles in Article 12 could be incorporated into domestic Australian law.
Sure. Okay. First of all, we remove the interpretive declaration, number one. Second of all, as per the CRPD Committee's recommendations in 2013 and 2019, that all legislation, in particular in regards to Article 12, be reviewed, and that accommodations, as defined by the CRPD, are put into such legislation and policies to support people with disability to have access to justice. And I also refer to the Australian Law Reform Commission's 2014 inquiry, which looked into Article 12 and said, for the purpose of this inquiry, I quote, it is the first declaration relating to Article 12 and decision-making which is of principal concern. There are differing views about the effect of this declaration, particularly in relation to the role of substitute decision-making, which prompt a reconsideration of its retention. So that was the Australian Law Reform Commission. And I am aware of the fact that, there is confusion within Australia, as identified by the Australian Law Reform Commission, about what is substitute decision-making and what is supported decision-making. And the CRPD is very, very clear. Supported decision-making supports a person to be represented before the law. It's not difficult. It can be done.
And it has been done, hasn't it, in at least one jurisdiction?
There has been in Wales witness
No,
intermediaries.
I mean in Australia.
South Australia introduced a disability justice plan, I believe. However, I am unsure as to its full implementation at this current time.
Some of the provisions in Victoria in their new guardianship legislation?
Some of the provisions, yes.
Yeah.
But it also needs to have, a national impetus. This needs to come from the Commonwealth. It has to come from the Commonwealth. Too often, the responsibility is pushed aside or deflected onto the states and territories. Yes, we have a fractured jurisdictional system, but we have to have the responsibility come from the Commonwealth, and that is very clearly directed from the committee.
Thank you. Yes.
I think the question that I asked about what needs to be changed has probably been answered in the questions from the commissioners. So unless there's any final matters that our members of our panel would like to raise.
Perhaps just before we finish, I will ask any of the legal representatives present remotely if they have any questions of members of the panel. If not, thank you. Sorry, Ms. Eastman, I think I might have interrupted what you're about to say.
Quite all right. So I just want to check that there's nothing final from our members of the panel that they want to say, particularly around what could be done to implement the CRPD rights and alternatively their vision for what Australia should look like in relation to rights protection. Any final comments, or have you covered that in the questions from the commissioners? Damien?
I won't miss the opportunity, Kate, if that's okay. Obviously, some sort of enforceable mechanism, bit like closing the gap, we think that as merit as an idea, needs some work to actually give that life, but we think that has merit, as in it would elevate disability rights. One of the things that we see with the Closing the Gap Day, even though can certainly critique it, at the very least, every day, one day for every year, the Prime Minister has to elevate Indigenous rights. It's on the national agenda. We think something like that, but in consultation with people with disability and their representative organisation, really has merit as a way to get more focus on disability rights. I think the lack of focus in Australian society is really, it has a very long way to go, and I think that may be one way to elevate things.
I agree with Damien, and we'll just add that, we need the disability representative organisations and disabled people involved in whatever, is the outcome and the way forward.
Nothing about us without us.
Correct. And all of us, not just, the non-Aboriginal people or the straight people, or it has to be the whole community.
Can I thank you all very much for your time and the care and thought that you brought to preparing for the session this afternoon. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you. I would like to endorse what Ms. Eastman has just said. Also, Ms. Reamer, I must apologise to you. I think I mispronounced your name, so I'm sorry about that a little earlier.
Okay, thank you.
Thank you all for coming to the Royal Commission and giving evidence, and as Ms. Eastman has said, for the thought that has gone into the contributions you have made today in the panel. We thank you very much.
Thank you.
Thank you.
Commissioners will take a short adjournment and then we'll resume with Professor Andrew Burns. I think we had 15 minutes, but I'm happy if you want to reduce it to 10 minutes.
It is now 3:06 p.m. We'll resume at 3:16 p.m.
Thank you.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Ms. Eastman.
Thank you. Commissioners, I omitted to ask you to receive into evidence the CVs of the participants in the previous panel.
Yes.
We will ask you to mark those documents, Exhibit 18.8 through to 18.10, and we'll prepare a list for
Shouldn't there be 4?
No, there's 3 CVs out of the 4 panels, and we've given you the reference to where the earlier CVs have been addressed in earlier exhibits.
Right.
So rather than make this confusing, we'll circulate a list to all of the participants and the parties with leave.
All right,
so
well,
they can see
the curriculum vitae that you've mentioned will become exhibit 18. Is it 18.8?
18.8 through
18.9 and 18.10.
10.
Thank you. Yes.
Thank you. So I can now see Professor Andrew Burns on the screen, and he's our final witness for today.
Professor Burns, thank you very much for agreeing to come to the Royal Commission to give evidence. We can see you. I hope we can hear you. Say something.
I'm very grateful for the opportunity. Thank you,
Yes,
Chair.
we can hear you. Thank you very much. I'll now ask Ms. Eastman to ask you some questions.
So you are Emeritus Professor Andrew Burns,
That's right.
and your address is known to the Royal Commission.
Yes.
And you have been, for a long time, a Professor of International Law and International Human Rights Law, most recently with the University of New South Wales.
Yes, that's right.
And you have provided to the Commission a very detailed curriculum vitae setting out the various positions that you've held in the Academy and your publications and some of the broader consultancy and research work that you've undertaken. Can I summarise it in that way?
Yes, that's fine. Yep.
And I'm partly doing so because I'm keen to get to the questions that I need to ask you. So we're going to focus this afternoon on the exercise of translating the CRPD, and for that matter, other international human rights law into Australian law and practice. And the Commission has heard during the course of today that the CRPD as an international law is not automatically part of Australian law. So can I start by asking you a few questions? International law creates obligations between nation states or countries. So it's the law that applies between countries. Is that right?
That's correct, yes.
And there's lots of different forms of international law, but the one we're focusing on is called a treaty. And a treaty is a bit like an international law version of a contract between perhaps 2 states, or in some cases, many states like the CRPD.
Yes, that's an analogy that's often used, although where you get multilateral treaties is often seen as also a form of legislation. So, but either analogy captures certain aspects of what a treaty is.
And while an international law might identify individuals as, for example, the beneficiaries of rights, the international law is about creating legal obligations for nation states rather than creating rights between individuals or for corporations. Is that right?
Yes, I think that's, as a general proposition, that's correct, yes.
I'm going high level at this point. We'll get into the details shortly.
Does it follow, Professor Burns, the duty bearers under international law and specifically pursuant to international conventions can only be states?
No, it doesn't. And the reason I said generally in terms of obligations is that there are certain areas where obligations are imposed directly on by international law on individuals or groups, particularly in the area of international humanitarian law. And in the area of corporations, there's a sort of evolving developments there, but they haven't gone quite as far as international humanitarian law. But the sort of obligations we're talking about, it's focused really on the state, and the state may have a duty to regulate the activities of private actors within its jurisdiction to make sure that they too don't infringe on human rights.
And in the case specifically of the CRPD, that is the position, I take it.
That's right. Yes, under it's specifically set out, indeed, in a number of the treaties that the obligation is to take all appropriate measures to ensure that private parties comply with or don't engage in discrimination.
So we've heard international law is not automatically part of Australian law, and this is a feature of our legal system. So when and how will international law be incorporated or become part of Australian law?
Okay, well, there are two broad ways in which that happens, and I'll speak about the major ways rather than the footnotes. The first is obviously the transformation or incorporation by legislation, so a primary statute, primary legislation, and that can be through a statute of the Commonwealth or the states or territories. And then secondly, by means of subordinate legislation or delegated legislation made by the executive government, generally within a framework of legislative authority conferred by the Parliament on a minister or someone else to make such regulations. In both cases, what is ensured there is obviously that Parliament is involved in changing, making, authorising changes to the law of the land and supervises those in the case of delegated legislation, so that that's the underlying principle. So the executive, which can unilaterally enter into treaties on behalf of Australia and bind Australia internationally, can't thereby change the law of the land without going through the Parliament.
When you're talking about the executive, you're talking about the national government at the Commonwealth level. So the states and territories, for example, can't say, oh, we're interested in signing up to some international law. So Queensland couldn't go alone to sign up to a treaty, could it? I
think the answer to that question is no. But when it comes to implementation, of course, depending on the particular treaty and the internal political arrangements, state legislatures may in fact be the ones who do the legislative implementation by primary or delegated legislation. There are quite a few instances of that.
And in this country, the Parliament doesn't have to give permission to the executive before the executive signs an international agreement. But Parliament does have some role in reviewing or deciding whether or not Australia should take the next step, which is ratify a convention before it has those international legal obligations. So sometimes we hear about signing and ratifying, and what happens between those two steps in Australia.
And perhaps it's worthwhile just describing the way in which Australia becomes bound by a treaty, what's known as being a state party to a treaty. And under the sort of treaties we're talking about, multilateral human rights treaties, there are two procedures generally. One is that you first sign it and indicate general support. You're not bound by it. You can't subvert its object and purpose, but you're not bound by it in its entirety. And then you can follow up by what's called ratification, ratifying the treaty, and then you do become bound by it. Or you can just come in with one fell swoop and do what's called acceding to it. So accession has the same impact. In Australia, you're quite right. There is no constitutional or legislative requirement that executives seek the permission of Parliament before it signs or ratifies the convention. However, from the mid-1990s, there has been an arrangement through Parliament by which the government must take to Parliament certain categories of treaties where it is proposing to take what's called binding treaty action. And that means to ratify or to accede to in the case of these sorts of treaties. And they go before the Joint Standing Committee on Treaties, which may carry out a hearing into the desirability of Australia becoming party to that treaty.
So do something called a national interest analysis to work out whether Australia taking on international law obligations is in the national interests?
Yes, that's correct. And it's a sort of explanatory memorandum, but it details things like what the treaty means, whether Australia is broadly in compliance, what sorts of consultation have been undertaken into the treaty at the national level.
And we're aware that there was that process undertaken in Australia for the CRPD.
Mm-hmm.
And I'll ask perhaps the representatives from the Australian government about that tomorrow. But does a country like Australia have to have, if I use the colloquial expression, its house in order before it takes on the international legal obligations?
In theory, no. Though often, I think Australia often says, and other countries often say that they won't ratify a treaty until they think they've got their house in order. That's not required because after all these human rights treaties, states generally adopt an assessment of their level of performance that is perhaps not shared by everyone. And as was said this morning, human rights treaties are also dynamic. And particularly where you have obligations of progressive implementation, of course, you may not be in full compliance yet because you're just starting on or partway along a journey to fully realise the guaranteed rights. So no, there's no requirement or expectation that you'll be in compliance immediately, unless the treaty says that particular steps have to be taken of that sort before you ratify.
And coming back to how Australia takes the international law and makes it part of the domestic law, I think the chair mentioned this morning that there's some constitutional issues there and whether the Australian government or the Commonwealth can use its powers under the Constitution to take the treaty and bring it into international, from an international law setting into a domestic setting. So without going through the complex legal areas of Section 5129 of the Constitution, is it fair to say that if the Australian government has taken on the international legal obligations, the Australian government has the constitutional power to take that international law and make it part of the domestic law?
I think that is broadly correct, yes. I mean, there is a test that the statute has to be reasonably adapted to the purposes of legislation and so on, and it's subject to constitutional prohibitions, but yes. But I guess it's worthwhile footnoting that it's not just 5129 external affairs power, but the Commonwealth can exercise any of its powers, legislative powers, to implement a treaty. But you'll often see reference to a treaty in implementing legislation where there's doubt as to whether some of the other powers go that far.
And we've seen that, for example, one of the first times was when the Commonwealth looked to the International Covenant on the Elimination of All Forms of Racial Discrimination to create the Racial Discrimination Act at a federal level, but that had some consequences, did it not, for some state laws that might have been inconsistent with the international obligations. So is that an example of the Commonwealth using its constitutional power to take international law and make it part of the Australian law, perhaps even regardless of what the consequences might be for the states and territories?
Yes, it is, and it's a Commonwealth statute, I guess, like any other, and Section 109 will apply to override any inconsistent state law to the extent of that inconsistency, as it did and was upheld by the High Court. Another obvious example, I think, is the Sex Discrimination Act, which also relied on the Convention on the Elimination of All Forms of Discrimination to extend its scope beyond what might otherwise have been possible. Though in each case, I think that there are now savings provisions. So the Commonwealth has been quite keen, along with the states, to preserve the operation of state and territory anti-discrimination law so that the Commonwealth Act are not seen as covering the field necessarily. So there's that dimension as well.
I think with the Racial Discrimination Act, the Act says something like in Section 7, Australia ratifies the International Convention. And then the International Convention is just set out in the back of the Racial Discrimination Act. Is that how governments take international law and make them part of the domestic law, just replicate the convention?
Look, I think there are a number of ways, and in preparation for this, I listed about 7 or 8. I don't know if you want me to bore you going through them, but there is a variety of ways. They may just say that the treaty has domestic law, has the force of law, or some provisions of the treaty shall have the force of law, or they may incorporate them within framework legislation like extradition and double tax treaties. Or, and this is where I think we get into those cases involving human rights, is that the treaty may include some terms or some definitions or provisions which pick up language in the international treaty, and they may or may not schedule the full treaty to the Act, or they may simply say one of the objects of this Act is to give effect to the treaty. But I think in the case of the Racial Discrimination Act, my recollection is that the original and still the first paragraph of Section 9 picks up the definition of discrimination on the grounds of race from the Convention and imports it pretty much directly into Australian law. So it's a sort of package. There are other provisions in the Act which are not found in the Racial Discrimination Act, but they are, of course, substantively giving effect to the general obligations in the Act. And that, I think, is the more common way of doing it. You'll often get a mix of language ported from the treaty into the Act. But generally, I think the preference, because of legal, cultural, but also drafting practice and problems in interpreting treaties in a domestic context, in an individual case, means that it's sometimes easier to paraphrase them, to substantively translate them into more usable language.
I want to ask you some questions about the way in which we interpret treaties and what that means for Australia. But before I get to that, can I ask you about some examples which we see in Australian states and the ACT, where the state governments have taken the international human rights law and used those international laws to have their charters of rights or human rights acts. So I want to ask you about these bills of rights, because we've heard that we don't have obviously a national bill of rights or a charter of rights, but we've seen some examples now in Victoria, Queensland and the ACT. We're going to hear tomorrow about the ACT. But can I ask you about that process of taking the international laws and putting it into state or territory legislation? There's no impediment on a state government doing that, is that right?
No, not unless there is some conflicting Commonwealth law, or unless there's the treaty level, there's a requirement there be a uniform national law, of course, but that's not a constitutional or limitation on the powers of the state under Australian law. Now, look, I think those are examples, and they're obviously very important examples of the way in which Australian law picks up certain human rights treaties. There are others. There, in the Fair Work Act, there are various international labour organisation conventions picked up, which are human rights conventions and so on. But in the case of the three statutory charters we have, essentially what they have done is that they've picked up selected rights, largely from the International Covenant on Civil and Political Rights, with some additional ones, as I think the Chair mentioned this morning, and they've transformed them slightly. They've made them fit better within Australian drafting style, but they're essentially meant to be interpreted with reference to the ICCPR and in some cases the International Covenant on Economic, Social and Cultural Rights. And those sources are made explicit in the statutes, and it's very clear that that's the case, and that's the approach that the courts and others have taken in interpreting those three statutes.
No, those laws that now operate in Queensland, Victoria and the ACT are often described as a dialogue model, and they seem, is it right, to be based on an approach taken in the United Kingdom with its Human Rights Act. And the UK was getting in a lot of trouble with the European Convention on Human Rights and having to appear in a court in Strasbourg. And so the UK said, well, I think we need to have something in our domestic law that will better protect the rights. And one of the objectives was not to end up in the Strasbourg court. But the model the UK used was one that looked at the particular system of government in the UK and the three branches of government: the lawmakers, so the legislature or the parliament, the judiciary, and the role of courts and tribunals enforcing rights, and also the executive, which you've spoken about in the Australian context, but perhaps the public service, the administrative decision makers. that's been replicated in Australia. Is that a way of looking at taking human rights and matching it with the way government works? Is this a new way of looking at taking international law into a domestic setting?
Look, I think there are other examples, and I think that the notion of dialogue also came out of Canada, which of course has a constitutional Bill of Rights. But yes, it's certainly the case that the three models that we have are derived from the UK model, although of course there's a fourth party in that conversation there, as you mentioned, the European Court, which we don't have in the context of Australia, notwithstanding the fact that complaints can be taken to various UN human rights treaty bodies. As was mentioned this morning, they don't issue binding international legal judgments. So yes, the goal of those was really, I think, to reflect concerns about giving too much power to judges and overriding the power of a democratically elected legislature. And that's more broadly reflected, I think, in the reluctance in Australia to adopt a constitutional Bill of Rights. And so this is the way that was seen as providing an enhanced protection, ensuring that the decisions of the legislature were to be respected. And if the courts found that they were in conflict with human rights, then the matter could be referred back to the executive government, the Attorney General, who could take it back to the legislature and explain whether or not the government was advising the legislature to change the law. So it was a dialogue, sort of a three-way dialogue between the legislature, the courts, the executive and back, but also I think between the legislature and the executive. Under each of those statutes, there's an obligation to present a statement of compatibility, so to explain how a piece of legislation is consistent with the listed rights. And that then goes before a parliamentary scrutiny committee or a portfolio committee in the case of Queensland. And so there is a back and forth then with the minister that may lead to changes. And that is also meant to help develop a culture of human rights within the public service, so that becomes part of the everyday part of legislative and policy processes.
Well, if we're talking about an international human rights law like the CRPD, which is not fully incorporated into Australian law, practice and policy, we've heard today that the CRPD is a very important tool in advocacy. And I wanted to ask you, is there any way that you can use international laws like the CRPD if they're not part of Australian laws? Is there a prohibition on using international law at all?
No, it's probably before I answer that question, it's probably important just to stress one element of or two elements of the Human Rights Act. One is that each of those acts requires the public authority, when they're making a decision, firstly to give proper consideration to human rights. So it's a mandatory consideration. They must take it into account and give it weight. And then secondly, they must comply with human rights in any decision or action that they take. And then the second very important element that was a significant change is that there's an obligation on courts, and indeed anyone interpreting statutes, but it's primarily of importance for courts, to construe existing or construe statutes generally where it is possible to do so without distorting the wording and the purpose of the statute, to interpret it consistently with human rights. So that's they're significant changes, and they're important because they represent changes from the situation of how you can use unincorporated treaties. So there are a number of ways in which you can use unincorporated treaties. Obviously, once Australia has ratified a treaty, I think there's a political expectation that the government will do something about it. So, I mean, as an advocacy tool, we've certainly heard about that today. It provides a framework, it provides a language, it provides a legitimacy for advocacy work, both generally, but also in specific cases. And I think that we've seen some of that in some of the work that's been done in Victoria. The other important aspect is it does provide a formal framework for policy development and public inquiries, and a number of those have been mentioned. The Australian Law Reform Commission inquiry into equality, capacity and disability in Commonwealth law from 2014 used the CRPD as a framework. The New South Wales Law Reform Commission in its 2017 review of the Guardianship Act used the CRPD as the framework, and I think it's been used in Victoria and other places, and other treaties are also used in that way. In the context of courts and that more formal process of litigation, unincorporated treaties can be still drawn on in different ways. Even if a treaty is not incorporated, if it's clear that the statute is intended to give effect to some or all of it, then the statute may be drawn on to assist in the interpretation of the treaty may be drawn on to assist in the interpretation of the statute. Although if the words of the statute are clear and not consistent with the treaty, then they obviously prevail. Ditto where particular words are taken from a statute. The same thing applies. Thirdly, I guess there's a more general presumption of consistent interpretation. So Parliament is assumed not to have intended to legislate contrary to its international obligations. There's a little bit of uncertainty as to quite when that applies, whether you need an ambiguity, what sort of ambiguity, but I think it's a well-accepted principle of statutory interpretation. And there are two others. One is the question of relevant consideration. It is permissible for administrative decision makers to take into account relevant treaties. It may be, unless the statute says they must, that you can't force them to, but they're certainly permitted to. And there is this rather contested concept of legitimate expectation, which I won't say anything further about, but the notion that it's expected that decision makers will comply with it. But that doubt has been cast on the status of that under Australian law. And then the final area, I guess, is the conventions, unincorporated conventions can be used as a guide or to be drawn on to develop common law principles. And there's at least one case in Australia in which that has been done with the CRPD involving undue influence in a case in the Victorian Supreme Court. So there, I think, the major ways in which unincorporated treaties can be used.
So at the international law level, once a convention or treaty is settled, there are particular rules that apply to interpreting the meaning of, in this case, rights in the international convention. And I think we tend to go to another international law called the Vienna Convention on the Law of Treaties. And that gives us a guide to interpreting the international law. But how, for example, would Australian politicians, judges, and decision makers using any of these international laws, how do they go about interpreting the meaning of the treaties and particular rights, for example?
Look, I think the answer is in relation to all the branches of government is that very similar approaches are adopted. And so, as you said, the Vienna Convention, Article 31 in particular, applies both when an Australian court is interpreting an international treaty, even if it's not mentioned in a specific statute, but it's relevant for that purpose, and also where there's specific language from that treaty. So that involves looking at the ordinary meaning of the text, but in the context of the treaty and in light of its object and purpose. So it's a broad approach to it. And when doing that, you can also have regard to the drafting history of the treaty. There are certain formal conditions around that. There has to be ambiguity, but in practice, I think most international courts look at it as part of a scanning of the scene before they delve in. But the Vienna Convention on Law of Treaties is the starting point. And that allows you obviously to focus on the treaty, also on how states have interpreted the treaty themselves, what's called state practice, and whether they have given slightly different meanings to the treaty. And you can also take into account other international obligations or other rules of international law that might apply to that.
That sounds like pretty hard work. If I'm a busy politician and there's a law that we've got to work out the meaning of international law. Is there an expectation that our politicians, judges and decision makers will be able to work their way through the Vienna Convention on the Law of Treaties to look at general comments, to look at state party reports? It sounds really hard. So how
Can
do
we
we approach
distinguish
it?
between politicians and judges,
No, I'm
please?
putting you all together for today's purpose.
There you go.
But it sounds, it sounds quite hard. Like, it sounds you have to know a lot about international law, and you want to understand how it works in an Australian context. How do you
Look,
go about doing it?
It can be complex, and for reasons which the chair referred to this morning, particularly where you've got sort of constructive ambiguity in order to get text, it can be hard. But these sorts of processes are part of the everyday work of attorney generals and the Department of Foreign Affairs and Trade. And yes, new issues come up, but often it's once you've done the work broadly once, it's not such a huge undertaking. So within government, there's enormous expertise. Within the realm of parliaments, there's also considerable expertise. They're obviously advised by the relevant minister and department. But the body I'm most familiar with is the Parliamentary Joint Committee on Human Rights, which of course is interpreting the 7 relevant human rights treaties all the time, and gets on top of this and is manages to deal with all those sources. But yes, it is at times a complex process. Sometimes it's not. But on the other hand, you having signed on to an international treaty, you want to make sure that you do in fact implement it. And I think courts, well, I think you only have to look at the practice of courts and see that in a range of cases of Australian courts, under the Refugee Convention, under the Fair Work Act, under a series of cases that with the assistance of counsel, then obviously they are able to get on top of these issues on the whole fairly well. And other bodies like the Human Rights Commission are available and do work of this sort in the human rights area.
I've heard some Australian judges in their decisions saying international human rights are very aspirational in nature, and this makes them difficult types of rights to bring into an Australian legal setting where we're much more comfortable with clear parameters and clear obligations and definitions. How do courts navigate those issues of rights that look aspirational in nature, but someone's seeking to give them effect in the Australian legal context?
Of course, they are aspirational. They're goals and values we want to achieve, but they're also embodied in positive instruments of law. I think that in terms of that, often there is perhaps a misunderstanding, or perhaps not a greatest familiarity on the part of everyone about what really goes on in terms of interpreting these. 30, 40 years ago, there was not an enormous amount of jurisprudence and case law of the sort that we have in other areas in relation to international human rights. Now there is. There's too much. So I think if you look at the experience of Australian courts, really at all levels, the best examples show that, depending on the nature of the right, they can do this work. The question of whether there are particular sorts of rights, in particular economic and social rights and progressive implementation obligations and so on, whether that makes it more difficult, I think there are two answers to that. One is that I think the progressive implementation argument is probably living to some extent in the past, at a time where there had been much less judicial application of economic, social, cultural rights. There are still elements around progressive realisation which cause difficulties for judicial application, but I think there are many of those problems have turned out to be not quite as worrisome as appeared. But in order to do that, I think you often then need to translate something like the Economic Covenant or the CRPD, with its general provisions about states having to do things, into slightly different language, in the same way that the human rights charters in Australia have translated the ICCPR into local language. And when it comes, I think, to dealing with big questions and questions of reasonableness and proportionality and and so on. I think when some in the judiciary make those comments, it always strikes me that perhaps they're putting aside the sorts of work that they themselves and others in courts are often involved in. I mean, the High Court, for example, in its work on the implied freedom of political communication in deciding whether or not state borders should be opened. A whole range of issues that courts decide on, which are broad policy issues or may have policy implications, I think, have their analogues in the international law area. And so I think it's one needs to approach it perhaps with a little bit more nuance than saying these obligations or they are simply not litigatable in a domestic court, that they don't produce sufficient judicially manageable standards.
Can I ask you just on this idea of progressive realisation? Because the Commonwealth the Australian government in its background paper has said, paragraph 4, implicit in the concept of progressive realisation is that states parties are obliged to achieve continuous improvement of conditions over time without backward movement. I don't think that's controversial, is it?
No.
And then it says any retrogressive measures require careful consideration and the full justification with reference to the totality of rights provided in the relevant convention and in the context of the full use of the maximum available resources. Can I just ask whether you've got a view about the approach to interpreting progressive realisation, that a retrogressive, if the starting point is there's no backwards movement, how then can retrogressive measures be justified on the basis of consideration of the maximum available resources? And perhaps related to that point at paragraph 10, the Commonwealth says that there's a reasonable margin of discretion. I don't know if you've heard that expression before, in choosing methods to implement progressively realisable rights, taking into account resource considerations. So I've just touched on those because it comes back to the question that I asked about trying to understand the concept of rights. But this is an approach that the Australian government seems to say there's a lot of discretion or a margin of discretion in how progressive realisation and those types of rights can be implemented.
I think there might be
a lot of questions.
Questions in there. So why don't we start with the first one about retrogressive and then move on to the next 4 or 5.
Okay, thank you, Chair and Ms. Eastman. Yes, the notion of non-retrogression comes out of the practice of the Committee on Economic, Social and Cultural Rights. And they have basically, it's not an absolute bar, as they say, but it has to be justified by very careful consideration. And the way in which they've suggested it be done is to look at various criteria. What were the alternatives? What other things are done? Does it impact particularly on disadvantaged groups and so on? And they're the sort of things actually which have been picked up by the Parliamentary Joint Committee on Human Rights in looking at non-retrogression as well. It's really a form of limitation of rights, I suppose. It can be quite difficult, I think, to assess, because when you're getting into those sorts of issues, it's generally a plea by governments that the economy is bad, or there's a shortage of things, or there are other priorities. And so it's essentially a resources issue, but it's quite difficult to line the government up and say, okay, here are all your items of expenditure, here are all the rights priorities, how have you allocated them to have the resources to those priorities? And there might be other human rights priorities as well. And so that's, I think, one of the systemic issues, and that's been pointed to certainly by the Parliamentary Joint Committee on Human Rights, which has sought to ask the government, when it appropriates money to various portfolio budget statements, to provide a human rights impact analysis of that, particularly where there are cuts to specific areas. But yeah, so that's it's probably all more you need to know on retrogression, but it's certainly part of international law. But it's not an easy out. It's not saying, oh, we can't find the resources. There's the state has to demonstrate that there are not resources and that there are other alternatives. Sorry, I'll pause there and then.
The next question, I think, related to margin of appreciation or whatever.
Margin of discretion.
Margin of discretion.
Yes. No, in terms of margin of appreciation, I think it's probably wise to avoid that phrase in this context, mainly because it's a creature of Strasbourg jurisprudence, the European Court of Human Rights, and it has a body of jurisprudence that varies according to area, and it's about the amount of deference in particular areas that an international court will pay to national institutions, legislatures, courts, and so on. But I think it's well accepted that under any treaty, really, unless the treaty specifies the specific outcome or the specific means by which an outcome is to be achieved. So, for example, you must adopt legislation, you must adopt a national law, then the state does have a certain amount of discretion as long as they achieve the substantive result. That, I think, also applies in relation to obligations which are progressively realisable, subject, of course, to the fact that it's not an open-ended, we can do what we want when we want obligation. It's very clear that there are specific procedural aspects of progressive realisation involving the drawing up of a baseline, the identification of, or the drawing up of a plan with benchmarks, monitoring procedures, and a timeline and progress. So it's not an open-ended, we can do what we want when we want. There has to be progress forward that is genuine. And the other thing I suppose it's important to mention here, both under general human rights law and under Article 4.2 of the Convention, which the Chair read out this morning dealing with progressive realisation, there is an important rider, and that is that both general human rights law and Article 4.2 recognise that economic, social and cultural rights may have some immediately applicable obligations, so obligations of immediate effect. And they, I think, the understanding of what they are has evolved over the years. They could include non-discrimination in various contexts. They may include things like not forcibly evicting someone from a house, even if you haven't, everyone in the population doesn't have housing under the broader notion. So I think it's important to recognise that, and that was consciously spelled out in the CRPD Article 4.2 because it was felt that one didn't want governments to be able to say, oh, it's all progressively realisable unless it's a clear civil and political rights obligation. That's not the case. It's a tight approach to assessing that, and there are a number of immediate obligations.
Against that background, can I ask you a little about the work of the Parliamentary Joint Committee on Human Rights and the work done by our Human Rights Parliamentary Scrutiny Act of 2011. That followed a national consultation on a Bill of Rights for Australia conducted by Frank Brennan and others. And the end result is we don't have a national Bill of Rights. But one of the recommendations was to think about the impact of law, and that before a law or a statute is passed, there is a role for Parliament to consider what the impact might be on human rights. And you've had a role as an advisor to the Australian Committee. And I wanted to ask you, and the commissioners have got your chapter, on how has the Parliamentary Joint Committee on Human Rights approached its lawmaking function or its scrutiny of lawmaking function with respect to the CRPD? Has it featured at all?
Yes, and as you said, I had the honour to be its external legal advisor from 2012 to 2014 and have followed it reasonably closely since then. Yes, the committee has jurisdiction to assess primary legislation and regulation, bills and sometimes primary legislation, and also delegated legislation for compatibility with the 7 human rights treaties to which Australia is party, 7 principal ones, including the CRPD. Yes, it has on a number of occasions looked at the CRPD, and perhaps I can mention 2 relatively recent ones and perhaps one other. In one of its recent reports, it's report number 2 of 2020, it looked at the disability discrimination regulations of 2019. They were the regulations designed to update and or extend exemptions under the Disability Discrimination Act of 1992, the Commonwealth Act, in relation to specific state laws. And the committee adopted the approach that it normally does with all the treaties, that it adopted the Vienna Convention approach. It looked at the text, general comments, concluding observations where relevant, and case law. And it adopted a pretty strong analysis of a number of the exemptions. And let me give an example. One was an exemption in relation to the power of a South Australian Minister for Education, I think, to nominate and direct a student to attend a special school. And the committee pointed out that that raises very significant concerns under the CRPD in terms of inclusive education, citing the general comment, but also the other relevant sources. However, that was it. I don't believe though there was a protective notice of disallowance while they looked at it, may have been put on it, the regulation I think is still there. So it didn't actually get rid of the regulation. What it did do, I suppose, was apply a sort of analytical blowtorch to it and draw attention to it. So perhaps there will be a subsequent action on it. Another one in which there, I think, has been perhaps a little bit more impact has been in relation to the various chemical and physical restraints applied in aged care facilities, which I'm sure you know has been a topic for some time. And the Parliamentary Joint Committee on Human Rights undertook an inquiry. And this was an inquiry which took public submissions and heard some hearings in relation to what were called the quality of care principles regulating restraints. I think the minister was Mr. Wyatt at that stage. And they looked at that and they came up with some very strong recommendations about that. And there have been a couple of iterations of those regulations now in response to that and other criticism. And I think in one of its very recent reports in 2021, it has also noted the improvements, but also noted a number of concerns. So I think there are 2 examples. They've also looked, I think, at the 65 age limit for admission to the NDIS and raised issues as to whether that is discriminatory against particular subgroups of people with disabilities. Is it an effective and useful instrument? Well, the commentators, I think, have generally been a bit disappointed. Perhaps their expectations were too high. But I think it's probably fair to say there have been relatively few immediate changes to bills in a particular process because of the part of the committee's criticism of them. Whether that flows through to the public service and to subsequent variations, whether it influences the thinking of parliamentarians in future is less clear. That's certainly one of the goals. Part of the problem is, I think, that the scrutiny comes at a stage which is very late in the legislative process. There's already an enormous amount of political and other capital invested in it. There's often very little time to actually examine and deal with these issues. So it's quite hard. That said, I think there have been some amendments, and particularly where there are calls coming from other sectors, the Parliamentary Joint Committee voice has perhaps helped to amplify the other voices. It's had more success, I think, with delegated legislation because, and it's brought about a number of changes there in different areas. And that's partly because it has the power to move disallowance motions and the Senate, in most cases, or the House could disallow. So there's actually a sword of Damocles hanging over the regulation if the flaws are significant enough.
So if the joint committee produces a report and it gives an assessment of a proposed bill, for example, interfering with human rights, does that operate in any way to prevent that bill being passed in a manner that might still have an adverse impact on human rights?
No, it doesn't. And it's one of the ironies, or one of the tensions perhaps, that you have parliamentarians wearing their hat as parliamentarians, performing a scrutiny role, adopting a view that there are serious problems or that a limitation hasn't been justified, and yet going out onto the floor of the parliament and voting the bill through. I think that's probably an irresolvable tension. And I think the advantage of the parliamentary committee has been the strength of the analysis that has been brought, and that the consistent analytical framework analysing limitations on rights has been put in. Parliament as a whole may not have chosen to follow the guidance that's been given, but at least it has been given and can be used as advocacy in other contexts, perhaps even in court cases and before UN human rights treaty bodies as well, I would imagine.
Commissioners, I'm conscious of the time. We've run over a little bit, so I might have to leave asking Professor Burns about models for implementing the CRPD into domestic law from other jurisdictions for another occasion. I'll just check if any of the commissioners have got any questions.
Commissioner McKeown.
Thank you, Chair. One question. Thank you, Professor Burns, for your evidence. You mentioned earlier that sometimes the history and drivers of a particular treaty or convention can lead to ambiguity around interpretation and implementation of that treaty. So taking into account that we've heard from witnesses and in our research report that a key driver of the CRPD was because of the exclusion and segregation of disabled people historically. So from your point of view and from a treaty interpretation point of view, what do you think are the obligations on Australia to implement inclusive system in line with the CRPD?
I understand that an analysis I prepared for the Commission is going to be tendered, and the bottom line of that analysis is, although it's a contested issue, my own view is the better view of the Convention's obligation, in particular Article 24, is that Australia needs to move progressively over some time to a transformed system of inclusive education, which does not, as a matter of principle, include special schools as a long-term separate form of education. And I think that is also the position taken by the CRPD committee.
Thank you, Professor Burns. Thank you, Chair.
Commissioner Ryan.
Professor Burns, there's lots of things I could ask you about, but I've noticed, I must say, people have been trying to convince us to codify or to make the CRPD a code of some sort. But I've noticed that it includes an awful lot of expressions like effective and appropriate means and so on. And I'm just sort of wondering just how useful will the CRPD be, particularly when many of the things that I must say have been brought before this Royal Commission today have been things, people have very basic requirements like housing, they want transport access. They're all things that are usually brought about by means of a parliamentary appropriation. Just how useful will terms like effective and appropriate or appropriate means be in getting those very basic human rights delivered, given that it really still in the end is down to a parliamentary process which allocates money?
Look, I think that's a critical question. And I think there are a couple of answers to that. And I think there are models around which would allow the transformation. Let me give you one that I was going to talk about from a common law jurisdiction, because there are lots of examples from civil law jurisdictions of general sort of bills of rights, protection of human rights of persons with disabilities. But there's a recent act adopted in Fiji, which engages with exactly this problem. It is a protection of the rights of persons with disabilities act based very closely on the CRPD. And what it does is it tries to respond to the problem that you have identified, which is to say, dealing with states, parties shall take appropriate measures. What does a court do with that, or what does a policymaker do? Well, they might take appropriate measures, but courts feel a bit uneasy in Australia with those sorts of provisions, I think. Other courts and other jurisdictions don't necessarily have the same thing, but we're working in Australia. And what they've done is that they've transformed it. So rather than saying state parties shall take appropriate measures to do X to ensure that someone has effective access to justice, they turn it into a rights formulation. So it is much more like our discrimination statutes or our other bills of rights statutes. And it becomes workable for courts, for public servants, and for others. And even in those cases, I think, where there might still be a little bit of doubt because they're general obligations, or there might be a little bit of discretion, I think what has been shown by the work done by the Human Rights Law Centre in Victoria, looking at how the Charter has been translated into everyday impacts, it's made a difference about people actually being able to get a protective screen door on their apartment because there's a human rights argument. In the article, I think that in 2012 or 2014, they had about 100 examples of really very practical ways in which having those rights, even if you're not in court, even if you're not doing the big picture stuff, can change. And the Victorian Ombudsman did a report last year or this year, I think, showing exactly the same in the context of the pandemic. So I think the statement of rights itself is important. You can translate it into a form that becomes workable, and it really does have an impact. I agree, some of the rights may need parliamentary appropriations. It may be that the parliamentary appropriations need to be made in a better targeted way. In many cases, of course, you won't need a parliamentary appropriation. It may just be a question of doing things right. Questions of effective access, well, we talk about in the common law, someone having effective assistance of counsel, I think effective access to transport. I think we can give a context too in terms of access, mobility access, and so on. So it's not without its problems, but I think there are examples. And Scotland has recently tried to do it in relation to the Convention on the Rights of the Child by dropping the CRC into a Human Rights Act style thing. But I think the Fijian example goes a little bit further. And there are other examples around the world of that sort, but that's just one which is a recent one and directly related to the CRPD.
Thanks.
Professor Burns, could you tell us, please, what the status in international law is of the work of the UN committee, specifically on the committee on the CRPD?
Yep. Well, as a general matter, I think the situation is fairly similar in relation to all the UN human rights treaty bodies as a matter of doctrine. Obviously, their output, even the formal decisional output under the optional protocol, when they adopt decisions or views, nor when they're purporting to set out, well, they are setting out interpretations of the provisions in general comments. They are formally not binding interpretations as such. I think that's very clearly established. But that's not the end of the matter. They're more than just my scribblings or the views of some academic scholar, because I think they're a body of independent experts which are entrusted with a particular function by the states parties who own the treaty in many ways. And therefore, I think it's become accepted by states, including Australia, that anything that the committee says in concluding observations, decisions, or whatever, is worthy of careful consideration and being given due weight. Doesn't mean you have to agree with it all the time, and obviously Australia and other states don't. Equally, though, it's frequent, and you can see this in the Australian government's submissions to the Commission and to other places. They frequently cite general comments of various committees and decisions as relevant and persuasive. So I think it goes down to what's the committee, what's the strength of the reasoning, how does it line up with the accepted rules of interpretation, and I think we have to accept that in some cases they may be pushing the envelope. And of course, we do have to remember that's part of their role, that part of the principles of interpretation of human rights treaties, that they should be liberally, dynamically, and generously interpreted in favour of the beneficiaries. But yes, it's a tricky area, but I think I've stated as best as I can.
Thank you very much. Now, I haven't acquired, have I? Whether council wish to ask questions. If there's any council that wishes to ask Professor Burns any questions, could they please so indicate? Apparently not. In that case, Ms. Eastman, does that conclude Professor Burns' evidence?
It does. As I said, there was a few other topics I wanted to explore, but we may persuade Professor Burns to come back at another time to continue that discussion. I was also going to play a short video, but I won't do that given the time. And I'll look at the tender of the Professor Burns material overnight and let you know in the morning. So I hope that concludes today's proceedings. And again, can I thank Professor Burns for his preparation, which was extremely thorough, and the assistance provided to the Royal Commission.
Yes, Professor Burns, I join thanking you. Your meticulous preparation is only to be expected of a professor from the Faculty of Law of the University of New South Wales, so it doesn't come as a surprise, but thank you very much for it.
Thank you, Chair. Thank you, Commissioners.
The Commissioners would adjourn then till 9:30 tomorrow.
9:30 tomorrow. We'll adjourn until 9:30 tomorrow.
The Royal Commission is adjourned.